Maybe permitted to mention affiliate side main.
Affiliate side will take up at two. Yes. Call.
May I be permitted to mention a matter, my lord?
Yes. Mention. No, mentioning is over. Appellate side, it's appellate side, come back at two. Yes.
Well, it's for the respondents. I beg to appear online. Well, it's for the respondents. I beg to appear online. Your lordships are able to hear me? Your lordships are able to hear me?
Yes, yes. Now we can hear.
Yes, yes. Thank you very much. I am appearing online today, but I will come on my turn physically once.
Right. Yes.
So great.
Arbitration Act now. My lord, kindly take, my lord, the impugned order. My lord, I was on that, my lord, volume 12, page 1570.
Three four two, no 343. 342. APOT. Sorry, APO 185.
It's 342, my lord, that.
Versus Gopal Das Bug, CND.
Yes, we are following that.
Yes.
Yes.
My lord, I will, my lord, just do a 5-minute, my lord, recap of what I had done, my lord.
Yes.
Now, my lord, I crystallize it, my lord, better. My lord, kindly, my lord, take, my lord, the, my lord, para 48, my lord, where the findings of the court start, my lord. My lord, which is, my lord, at page 1587.
Right. Yes.
Now, my lord, kindly note one thing. Para 48 to para 54, that's pages 1587 to 1592.
Yes.
My lord, answers the question, my lord, is SSSMIL an affiliate of the Bhaiya group? Now, my lord, I had, my lord, first submission I had made, my lord, was, and my lord, kindly make another note, SSSMIL is, my lord, Chem Crown. My lord, that is, my lord, also, my lord, it comes through, my lord, in, my lord, the order. Now, my lord, the question, my lord, I had, my lord, I'm just indicating to your lordships, my lord, the submission I had made. My lord, the first, my lord, is, my lord, that a wrong question, my lord, has been put, my lord, is Messrs. SSSMIL, an affiliate of the Bhaiya group. My lord, this is in the context of, my lord, the definition also of affiliate, my lord, which is there in Schedule 5 and Schedule 7.
Yes.
My lord, it encompassing, my lord, juristic entities and, my lord, including a parent company. My lord, that is, my lord, what, my lord, it is looking at. Second, my lord, is, your lordship will find, my lord, 3 findings here, my lord, in this paragraph, that, my lord, BG Chemicals has a controlling interest. My lord, kindly see, was not serially disputed the shareholding of Bulaki and his family members in BG Chemical,
Yes.
which has a controlling interest in such. My lord, this finding, my lord, is, my lord, completely contrary to, my lord, fact and, my lord, law. My lord, de facto, de jure, my lord, it is, my lord, not, my lord, a correct finding. Now, my lord, the second is, my lord, really, my lord, this is a reiteration, except to say that, my lord, then, my lord, kindly see, which has a controlling interest, except to say that members of Bagri family are also shareholders in SSMIL, the control of Bulakidas Bhaiya in SSMIL through BG Chemicals could not be seriously disputed. So, my lord, control again of, my lord, Bhaiya, my lord, of, my lord, SSMIL is, my lord, only through, my lord, BG Chemicals. And BG again, my lord, has 25.65% shareholding. Just, my lord, it has negative control. It is, my lord, well below the threshold of, my lord, 50% control. Or, my lord, in other words, majority control. Then, my lord, the third, my lord, finding, my lord, which is arrived at, my lord, certain paragraphs, that's, my lord, paragraph 9, 16 and 17, my lord, of the affidavit in opposition has been set out. My lord, from pages 1588 to 1589, and my lord, at 15, my lord, 87 bottom, on the contrary, at page 9 of the affidavit in opposition, there is an indirect assertion to that effect. Now, my lord, what the assertion is, my lord, is it, my lord, Bhaiya having controlling interest, my lord, in BG Chemicals, or, my lord, having controlling interest, my lord, in SSSMIL, my lord, is not, my lord, apparent, and I, my lord, placed it last time. My lord, there is nothing, my lord, to show, my lord, that there is, my lord, any, my lord, controlling interest, any, my lord, indirect, my lord, assertion to that effect. Now, my lord, paragraph 49, which I had placed, my lord,
Yes.
my lord, is, my lord, where inferences are drawn. Kindly note, my lord, it is inferences are drawn. My lord, now, my lord, kindly see, how are these inferences being drawn? From a conjoint reading of the extract from the affidavit as above. Those are, my lord, the 3 paragraphs of the affidavit in opposition. The declaration of the arbitrator in the first sitting, which I have also placed, also extracted here and above. The shareholding of BG Chemicals Private Limited, then, my lord, it's 27 odd % shareholding in SSIML, and other shareholders of SSIML, it could be inferred. Kindly mark this. My lord, other shareholders of SSMIL, it could be inferred that Bulakidas Bhaiya has overall control and management of SSMIL and CNE Limited. My lord, he's a shareholder of CNE. My lord, respondents also shareholders. That was the battle in the 397. As to, my lord, who should control. My lord, that was, my lord, settled. Now, my lord, SSMIL, my lord, has overall control and management. So, my lord, I'll take it, my lord, all documents, my lord, would show overall control and management of, I am challenging first SSMIL. Now, my lord, the second is, it can also be inferred that managers, directors and employees are accustomed to acting as per the sole wish, kindly mark the words, sole wish and dictates of the said Bulakidas Bhaiya. Now, my lord, this is, my lord, completely, my lord, we first don't know, my lord, which manager, my lord, manager of which entity, director of which entity, nothing. Now, my lord, I will, my lord, assume, my lord, that it is SSMIL. My lord, even this, my lord, is not borne out from the records. Now, my lord, here I had left a little gap, my lord, of the records which I must show to your lordship. My lord, kindly, my lord, take, my lord, page 1335. Which volume is 1335?
এর আগের ভলিউমটা 11
Ignores that boundaries also have shares paragraph. Please do go. I know that. I'm making myself. My lord, this is, my lord, page 1335. My lord, it should be, my lord, the previous volume, my lord, volume 12. Oh, volume 11, sorry. No, it's volume 10, my lord. It's volume 10. Now, my lord, kindly have a look, my lord, at page 13. My lord, it should be 1333. My lord, in, my lord, the section 34,
Yes.
my lord, a supplementary affidavit was filed by the Bagris. Now, my lord, kindly have a look at page 1335.
Yes.
I, Anil Bagri, son of so-and-so, aged by faith, residing at so-and-so, do hereby solemnly affirm. My lord, kindly come to, my lord, para 2, my lord, 6 lines from, my lord, the start.
Yes.
7 lines after annexure F. Similarly, in paragraph 13, a reference has been made to the shareholding pattern of SSMIL as taken from its own website, and such document has been marked as annexure 8 and the details of the directors as well as the shareholding pattern of BG Chemicals has been marked as Annexure I. So the petitioners respectfully submit that due to an inadvertent mistake made during filing of the said petition, these documents have not been annexed. The petitioners further submit respectfully that the presence of these documents are essential for effective, hence the petitioners humbly pray for leave, etc. Now, my lord, kindly have a look at, my lord, Annexure H, my lord, which starts, my lord, at page, my lord, 13, my lord, 51. My lord, it should be the first folded page, my lord.
Yes.
My lord, your lordship will find that the company concerned, my lord, is Standard Shoe Sole and Mold Company, SSSMIL.
It's the typed copy.
My lord, there's a typed copy in 1351A, my lord, but it's, my lord, hey, Dhruvo, let me proceed. If the learned judge cannot read, I'll never finish. Otherwise, I'll never finish, my lord. I like finishing, my lord, quickly, my lord.
Let to look at the original
Yes, my lord, if your lordship, my lord, has a problem, my lord,
problem. I will.
yes, my lord, 1353, my lord. Kindly come straight away to 1353. My lord, if your lordships have a problem, my lord, I can, my lord, go to the next page.
Without you doing it, we will shift.
Yes, my lord. Now, kindly note, my lord, the heading, my lord. Summary statement holding of specified securities. Now, my lord, kindly see category of shareholder. My lord, promoter and promoter group.
Yes.
Lordship has that?
Yes.
There are, my lord, number of shareholders are 108. Now, kindly note one thing. Bulaki Das Bhaiya out of this, my lord, the only allegation of this is of BG Chemicals. Later, my lord, some other shareholders come, which I shall explain. This is 35.42. Kindly see the public. It's a listed company, my lord. 64.58.
This is SSMIL.
SSSMIL.
Yes, you showed it.
Yes. Now, my lord, kindly come to, my lord, 1354.
Yes.
My lord, this is again statement holding. My lord, of, my lord, the shareholders. Now, most important, my lord, kindly come to 1355.
Yes.
My lord, kindly see now the statement showing shareholding pattern of the promoter and promoter group. Now, my lord, in the middle, your lordship will find table 2, statement showing shareholding pattern of promoter and promoter group, Indian,
Yes.
that's individuals, Hindu undivided family. There are, my lord, 106. And, my lord, any other, there are 2. And, my lord, kindly see, my lord, the shareholding group, my lord, is 9.67 for individuals and HUF,
Yes.
and 25.75, my lord, for others. Now, my lord, this 25.67, my lord, is of the others BG Chemicals. There's no other entity, my lord, which has been, my lord, tagged. Now, my lord, kindly come to my lord, individuals stroke Hindu undivided family. Now, my lord, here, my lord, none of the Bhaiyas or, my lord, Maheshwaris, please. 1359, my lord, if your lordships.
Yes.
None of the Bhaiyas, my lord, who are, my lord, mentioned here, are, my lord, members of Bulaki Das Bhaiya family. Now, my lord, who are they? My lord, they are, my lord, the brother and stepbrother of Bulaki Das Bhaiya and Rama Bagri. Rama Bagri is of the Bagri group. My lord, sister of Bulaki Das Bhaiya, my lord, had, my lord, married into the Bagri family. They are the in-laws. So, my lord, we have, my lord, Rama Bagri, we have Bulaki Das Bhaiya. And all the other Bhaiyas and Maheshwaris named here And this total shareholding is 7 odd %. My lord, if your lordship adds up, your lordship will, my lord, come to that, my lord. I'm told, my lord, close to 7%. My lord is, my lord, 1.081, etc. All these are held by, my lord, the brothers or step brothers and sons and daughters-in-law of, my lord, BD Bhaiya and, my lord, Rama Bagri. And they are, my lord, not mentioned as, my lord, giving, my lord, BD Bhaiya, my lord, a controlling interest. It is only, my lord, through, my lord, BG Chemicals. And that, my lord, in my respectful submission, my lord, this is what I wanted to show, my lord, other shareholders. The lordship's aware, my lord, that in a listed company, my lord, the promoter float can go up to 75%. Now, my lord, even then it's possible for, my lord, Bhaiya to have control by, my lord, voting arrangements, shareholder agreements. These are all possible. These are all, my lord, in the day. But, my lord, none of that is relied on here. And, my lord, the inference drawn, my lord, is that, my lord, only act solely under the control. My lord, there has to be, my lord, some evidence on record. There is none. Completely and wholly absent, my lord, in this, my lord, case. Now, my lord, kindly come to, my lord, paragraph 50. My lord, of, my lord, the impugned order. My lord, which is at, my lord, page 1590, my lord.
আচ্ছা এবার পরের ভলিউমটা বার করে রাখুন
My lord, the two volumes, my lord, 12 and 13. My lord, 12 and 13.
এরপরই 13টা লাগবে yes sir.
Now, my lord, in GA1 of AP so and so, it has been averred that Bulaki Das.
চাইছি
I'm
সেটাই
sorry.
চাইছি আমি যা দিতে বলছি দাও না sorry
No, no.
590 is the last page.
My lord, it's the last page, my lord. Of,
that's why we want it in
Yes.
advance they're trying to convince us that it is not being read.
now, my lord, in পরের ভলিউমটাও দিয়ে দিন
take it
I'm sorry. My lord, in GA1 of AP 364 at para 3, it has been averred that Bulaki Das Bhaiya had founded Chemcrown India Private Limited. Now, my lord, kindly mark the words. It was private, my lord, then, which is the former name of SSS MIL. Now, my lord, the character of the company, my lord, has undergone a complete change. My lord, setting up a company is one thing. To be in control of it on a particular date, my lord, is another. My lord, BG Chemicals Private Limited remains private limited. My lord, it might have been a subsidiary of, my lord, BG Chemicals Private Limited. We don't know when it was founded. But, my lord, first subscriber was Bulaki Das Bhaiya because he was a founder. No dispute. My lord, we are concerned with the present. At the time of, my lord, the alleged infraction of, my lord, Schedule 5 and Schedule 7. My lord, this, my lord, then, my lord, kindly see the next inference which is drawn. Para 50. Mr. Bhaiya was personally present in most of the sittings in the arbitration. It could, therefore, not be difficult to believe that he must have personally attended most of the conferences with the learned arbitrator at the time of briefing for appearances in connection with so-and-so between January. My lord, with the greatest of respect,
but in the
there's nothing.
right no Mr. Bhaiya was present for
The arbitral sitting, those are the minutes, my lord, which show that, my lord, he's a claimant. My lord, it's natural, my lord, for him to be present. But my lord, the fact that he attended arbitration sittings
Yes.
would necessarily mean that, my lord, he must have attended conferences, my lord, concerning appearances to be made, my lord, by the learned arbitrator in a matter where, my lord, the learned arbitrator was appearing, my lord, for SSSMIL. My lord,
Pulakidas Bhaiya has control over C and E, the claimant.
my lord,
He has, what is the
my lord, that's the fight, my lord, for control. My lord, in 397, 398.
Oh, that is the
Yes, yes, my lord, that is. So, my lord, CNE, that's the bit which gets, my lord, settled. That, my lord, we buy out the Bagri shares.
All right.
Because, my lord, both were in management and had shareholding. My lord, CNE.
So he had an active interest in the claimant company.
Correct. And himself, he's a joint claimant, my lord.
In himself, rather.
Yes.
Yes.
So, my lord,
Vis-a-vis
yes,
the claimant.
yes, and he has to be there, my lord, at the arbitral sitting.
Does not necessarily translate into his being
Correct,
present
being
at
present, my lord.
where his controlled company has 25 point something.
Correct. My lord,
That too in the conferences.
correct. My lord, this inference, my lord,
Even if whether he attended the conferences in this particular arbitration proceeding, we are not aware of that.
no, no.
Might have attended the arbitral.
Correct,
Whether
correct,
he went to the
correct,
conferences,
correct.
might not have
No.
gone.
Now, my lord, family controlled companies, then, my lord, para 51 and 52, my lord, are, my lord, very important. Family controlled companies are commonplace in, I'm sorry. Now, my lord, kindly see, family controlled companies are commonplace in India. Yes, lots of books have been written. The control of the family is exercised either through, kindly note, direct shareholding of the family members, no problem, or through other companies controlled by the same family or a member of the same. So the corporate entity, my lord, has to be also controlled. Now, my lord, I come to, my lord, ArcelorMittal, which is quoted here. The above proposition is clear from the expression control and management as explained succinctly in the case of ArcelorMittal at paras 50 and 51. Now, my lord, before I place this, I want to show, my lord, three provisions, my lord, which are of importance because that was being considered, my lord, in ArcelorMittal. Now, my lord, the first, my lord, where's the company?
The Arbitration and Conciliation Act.
No, no, my lord,
Of
the three acts which
Provisions?
were under consideration,
Answer.
my lord, the provisions, my lord, were, my lord, in fact, there were two acts and one regulation. My lord, the two acts were the Companies Act 2013. That's, my lord, the provision was section 2, subsection 27. My lord, that's, my lord, control.
Yes.
Then, my lord, regulation 2(1)(e). My lord, this is the takeover regulations of 1997. Now, my lord, we have, my lord, I think 2020, my lord. But, my lord, this was, my lord, what was under consideration. And, my lord, section 29A 1C of the IBC. Now, my lord, I want to start with, my lord, section 29A 1C, my lord, of, my lord, the IBC. You have copies? Yeah. My lord, we've got books.
Yes. আইবিসিটা আনিয়ে রাখবেন।
এটা খুলে দিই
আচ্ছা ওখানে লাগবে সবই কেন যা অ্যাসাইন হয়ে আসছে যেগুলো সেগুলো ওই ম্যাটার উল্লেখ
ওটা দিই
ওই ধরনের ম্যাটার।
the page numbers খুলে দিয়েছো তো
My lord, the relevant page, I believe, had been opened, 29 capital A. My lord.
Yes.
Now, my lord, kindly see persons, the heading, my lord,
Yes.
persons not eligible to be resolution applicant. Now, my lord, kindly see my lord, a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person, my lord, kindly see C, at the time of submission of the resolution plan has an account or an account of a corporate debtor under the management or control of such person or of whom such person is. So, my lord, control. So, who was, my lord, ineligible would be a person who had an NPA or was in control of a corporate entity which had an NPA. My lord, they were, my lord, excluded. That's what we are really concerned with. My lord, in, my lord, ArcelorMittal. Then comes, my lord, the SEBI regulations, my lord, of 1997. My lord, it's,
Xerox হয়েছে marked as views.
my lord,
এটা একটু তো দিচ্ছি।
Oh,
You
আচ্ছা।
keep that.
you want? चाहिए?
এটা রেখে দিচ্ছি, IBC টা আনিয়ে রাখতে হবে।
আমারটা মার্কড আছে, দিয়ে দেবো তো। My lord, kindly take, my lord,
থাক, যদি লাগে পরে দিচ্ছি।
my lord, your lordships may keep the book, my lord, I might be coming back to it also.
Yes, we keep
Yes.
it. Yes, for the timing.
Yes, no, even otherwise, I said, my
No,
lord.
no. We have
Now, my lord, kindly, my lord, take, my lord, regulation 2. Just, my lord, 2C is what I'm really concerned with, my lord, 21C. In these regulations, unless the context otherwise requires, kindly see C, control. Lordship has that, my lord?
Yes.
Shall include the right to appoint majority of the directors or to control the management or policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, including by virtue of their shareholding or management rights or shareholder agreements or voting agreements or any other. So, my lord, we can, my lord, imagine various situations. My lord, I may not have 51%. I have founded, my lord, the company. I can have an entrenched article which can never be altered. Under the new act, there is a concept of an entrenched article which cannot be amended, my lord, unless, my lord, the resolution, my lord, is even more than special resolution. It could be
Entrenched, we are sorry, the second phrase.
Yes, my lord.
Entrenched,
articles of association.
entrenched. Sorry.
So, my
That's
lord,
why it's entrenched, because it
Correct.
cannot be changed.
yes, my lord, it cannot be altered by the, normally articles can be altered,
Yes,
my lord, by, my lord, a special resolution.
yes.
But, my lord, an entrenched is one which requires something more. It could provide for 90%, my lord, voting to have that amended. So, my lord, by an entrenched article, I can be given rights. I can have veto powers, my lord, which is negative control. I can have affirmative powers, which is positive control. I can have a voting arrangement. Other shareholders, on these issues, you will vote along with me.
Yes.
Then, my lord, it can have, my lord, excluded matters. That, my lord, shareholders.
Mr. Mukherjee, we request you to just tell us, clarify this, because it's not clear to me.
Yes.
That this negative right you are saying, not affirming,
Yes.
affirmative rights.
Yes.
Negative, where do we get that? That if you have vote up to this in the Companies Act.
Yes, no, my lord, this has been case law, my lord, that one can block a resolution. Leading case, my lord, was, my lord, an English case, which has later, my lord, been, my lord, approved, my lord, by, my lord. That's, my lord, Clemens and Clemens. My lord, 1976 to All England. I don't remember the page, my lord. I'll just, my lord, that's, my lord, where, my lord, the fight was between an aunt and a niece. My lord, aunt, my lord, niece had over 25%.
Yes.
An amendment was proposed by virtue of which she would lose her 25%.
Please cite at least one judgment on that. Maybe
Negative
Clemens versus
control.
Clement. Yes.
Yes.
Because we want to look into that. Later on, you can cite.
No, I can, just get it, just get it. Just, my lord, 1976, my lord, the references I'm giving your lordship.
Yes, yes.
1976, to All England report,
Yes.
my lord, 268.
All right.
And my lord, your lordships will find it, my lord, at pages 280 to 282. My lord, this is the advantage of, my lord, having this, my lord, because in some other case, my lord, it's been cited. So it's, my lord,
All
here.
right. So you get the link.
Yes.
We'll get it.
And my lord, there are, I'll just get this. Now, my lord, it is also there, my lord, in ArcelorMittal, which has been cited. Now, my lord, please don't get into it. If you have not attended a conference, don't open your mouth. Now, my lord, kindly take the judgment now. My lord. So, my lord, I have shown your lordships Companies Act.
Companies active.
My lord, kindly take, my lord, the Companies Act, my lord, section 2, my lord, 27,
Yes.
subsection 27. My lord, I have a copy. My lord.
No, we have that. Companies active. Control.
My lord, kindly see section 2, subsection 27.
2 bracket 20.
Control.
Page 14 আছে page 14 রোমান না আর পরে রোমান না আরবি yes control
Control shall include the right to appoint majority of the directors or to control the management of policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, including by virtue of their shareholding or management rights or shareholders agreements or voting agreements or in any other manner.
almost similar
Now, my lord, kindly have a look at, my lord, in ArcelorMittal, my lord, the point had been taken, my lord, was to the effect that, my lord, ArcelorMittal, my lord, who was bidding, my lord, for, my lord, one of the SR group of companies, my lord, was ineligible to bid by virtue of the provisions of 29(1)(a). There was another company where, my lord, it was, my lord, a partner shareholder, a joint venture, my lord, which had, my lord,
NPA.
which had become an NPA. My lord, the argument was that, my lord, just before submitting resolution plan, my lord, he had, my lord, divested himself of that shareholding and therefore contended, my lord, that he was, my lord, not, my lord, ineligible. Now, my lord, in that context, my lord, control issue, my lord, came up. My lord, this was the first 29(a), my lord, matter, my lord, in a, my lord, which went, my lord, to the Supreme Court. Now, my lord, kindly take. No, I want to read it. Sir. Yes. My lord, kindly.
Citation.
My lord, this is 2019, 2 Supreme Court cases, page 1.
48 onwards.
My lord, kindly come to, my lord, paragraph 46,
yes
which is, my lord,
61.
at page, my lord,
61.
61. my lord.
yes
My lord, according to us, it is clear that the opening words of section 29(a) furnish a clue as to the time at which clause C is to operate. The opening words of section 29(a) state a person shall not be eligible to submit a resolution plan. It is clear, therefore, that the stage of ineligibility attaches when the resolution plan is submitted by a resolution applicant. Now, my lord, kindly come to paragraph, my lord, 48 and, my lord, 49.
yes
The expression management would refer to the DORA management of a corporate debtor. The DORA management of a corporate debtor would ordinarily vest in a board of directors and would include, in accord with definitions of manager, managing director, and officer in sections 253, 254, and 259, respectively, of the Companies Act 2013, the persons mentioned therein. the expression control is defined in section 227 of the Companies Act as follows, which I have placed. The expression control is therefore defined in two parts. Kindly see, my lord, how this is being. The first part refers to de jure control, which includes the right to appoint a majority of the directors of a company. So, my lord, if I have, my lord, more than 50%, I can appoint, my lord, directors. The second part refers to de facto control. So long as a person or persons acting in concert directly or indirectly can positively influence, kindly mark the words, positively influence in any manner, management or policy decisions, they could be said to be in control. A management decision is a decision to be taken as to how the corporate body is to be run in its day-to-day affairs. A policy decision would be a decision that would be beyond running day-to-day affairs, that is long-term decisions. So long as management or policy decisions can be or in fact are taken by virtue of shareholding, management rights, shareholder agreements, voting agreements or otherwise, control can be said to exist. Thus, the expression control in section 29 AC denotes only, now kindly mark this, positive control, which means that the mere power to block special resolutions of a company cannot amount to control. Control here, as contrasted with management, means de facto control of actual management of policy decisions that can be or are in fact taken. A judgment of the Securities Appellate Tribunal in Shubham Ventures and SEBI made the following observations qua control under the SEBI and Takeover Regulations 1997 were controlled as defined in Regulation 21E in similar terms as in Section 227 of the Securities Appellate Tribunal held. And my lord, I want to, my lord, place this because, my lord,
Same thing.
no, the finding which has, my lord, of the Securities Appellate Tribunal on control, which was, my lord, really affirmed, my lord, by the Supreme
The
Court.
Supreme Court in the previous paragraph probably says the same thing. Anyway, please
My
read.
lord, this is, my lord, if I may put it, my lord, even better put.
Wait.
My lord, my lord, at times, my lord, we ignore, my lord, the lowest court.
No,
But,
no.
my lord, at times, my lord, I quite often, not why at times, my lord, in the older, my lord, decisions, it's very often, my lord, that High Court has been set aside and the Munsif's order, my lord, has been affirmed.
He's so many good judgments.
Yes. My lord, which, my lord, some of us tend to, my lord, overlook. Some of us don't even look at other high courts, which I think, my lord.
Nowadays, we can identify with the munsifs, in fact, how they feel also.
Yes, absolutely.
The high courts can
Yes,
identify.
I know. Now, my lord, kindly have a look at,
Yes.
my lord, the Securities Appellate Tribunal held. The term control has been defined in Regulation 21C of Takeover Code to include so and so. My lord, 6 line later. This definition is an inclusive one and not exhaustive. And it has two distinct and separate features. The right to appoint majority of directors, or two, the ability to control the management of policy decisions by various means referred to in the definition. This control of management of policy decisions could be by virtue of shareholding or management rights, or shareholder agreement or voting rights, or any other manner. This definition appears to be similar to the one given in Black's Law Dictionary, where this term has been defined as under. Then, my lord, this is Black's quoted. Control, according to the definition, is a proactive and not a reactive power. My lord, that's what I was submitting. But, my lord, after having read this judgment, my lord, now, my lord, kindly see. It is a power by which an acquirer can command the target company to do what he wants it to do. Control really means creating or controlling a situation by taking the initiative. Power by which an acquirer can only prevent a company from doing what the latter wants to do is by itself not control. Kindly note this. In that event, the acquirer is only reacting rather than taking the initiative. It is a positive power and not a negative power. In a board-managed company, it is the board of directors that is in control. If an acquirer were to have power to appoint majority of directors, it is obvious that he would be in control of the company. but that is not the only way to be in control. If an acquirer were to control the management or policy decisions of a company, he would be in control. This could happen by virtue of a shareholding, etc., etc. The test, now kindly see, really is whether the acquirer is in the driving seat. To extend the metaphor further, the question would be, well, this is what I like, my lord, about whether he controls the steering,
Yes.
accelerator, the gears, and the brakes.
Yes.
If the answer to these questions is in the affirmative, then one would be in control of the company. In other words, my lord, kindly see,
Brakes would go out. Brakes should not be there.
brakes by itself is not good enough.
Brakes on itself maybe, otherwise
Yes, but otherwise it's relevant.
This
It's
is
absolutely
reactive.
true. Yes. Now, my lord, it's reactive to my lord if he suddenly realizes that his initiation, my lord, has been such that he's going too
accelerator
fast.
would have done.
Yes.
Yes.
Now, my lord, kindly see. In other words, the question to be asked in each case, and this is very important, would be whether the acquirer is the driving force behind the company and whether he is the one, as it fell from your lordship's, my lord, the accept providing motion to the organization. If yes, he is in control, but not otherwise. In short, control means effective control. My lord, I thought, my lord, this was, my lord, very aptly put. And my lord, this decision, my lord, this paragraph, my lord, has been quoted by the learned judge. And yet, my lord, the learned judge, my lord, has held that with 25.6% shareholding, my lord, Bulakidas Bhaiya, my lord, is in control, my lord, of SSSMIL without anything more. And my lord, when there are, if I may use the expression, contra facts also on record. My lord, SSSMIL was initially a private limited company. It has now become public. My lord, total promoter group shareholding is, my lord, 35 odd %. I showed your lordship from the chart. My lord, of which, my lord, Bulakidas is in control of only 25.66. And that through, my lord, BG Chemicals, where, my lord, his family alone, my lord, has over 90%. I'm not disputing, my lord, that position.
Right.
So, my lord, the facts as are there before the court, my lord. I only need to show this. Do not, my lord, extend, my lord, do not support, my lord, a finding, my lord, of control of, my lord, SSSMIL by Bulakidas Bhaiya.
He and his family, extended family, hold how much in SS?
My lord, extended family, sisters, brothers as well. They were no part of this. My lord, they hold, my lord, total, my lord, 7 odd %, my lord. That's the promoter group. So 25
added together 25.6 plus 7.
730. Even then it doesn't.
33. Even then, because we are looking at the broader perspective, the takeover regulation.
Yes, but my lord, that allegation has to be
Allegation
made.
is not
That,
there.
my lord,
Even
those-
then we are. Yes.
That, my lord, those three, my lord, step brothers' families and my lord, own brothers' families, and my lord, their son and their daughters-in-law.
Because of this definition, individual or in concert.
So that pleading, concert is a question of fact.
Pleading, and there had to be good relation, and other things are there.
Yes, my lord,
Might
all
not
that.
be, might be
And
my
my lord,
relative.
case is only that because in BG
Like-
Chemicals you have that. Because
Yes.
the others, my lord,
Through
may-
BG.
yes, my
entire.
lord, the others, my lord, the sister, my lord, some
Yes.
brothers may not have joined. It's not expected, my lord.
Just
That's
because he's a relative or she's a
Correct,
relative does
yeah.
not mean.
by itself. In fact, there have been cases where, my lord, promoters, my lord, have been, my lord, at, my lord, in,
Loggerheads.
at loggerheads.
No, otherwise, they'll know family matter before.
Correct, correct. Yes. Now, my lord,
Says you can be a promoter but not have control. Because it's all.
now, my lord, kindly come to,
Yes.
my lord, I had reached up to, my lord, para 53.
50.
Yes,
50.
my lord, which is, my lord, ArcelorMittal, etc., my lord. Now, my lord, kindly come to, my lord, para 54, my lord, at page, my lord,
192.
1592, my lord.
This is on that affiliate part of it.
Yes. Now, my lord, kindly have a look at this. Given that the definition of affiliate under section 12 of the Act encompasses all the companies, including the parent company, this court is hesitant to hold that SSSMIL is an affiliate of CNE of the Bhaya Group in the arbitration. Mr. Ghosh's argument, my lord, I'm hesitatingly holding now, my lord, we'll proceed on that basis. Mr. Ghosh's argument that an individual, Bulaki Das Bhaya in control and so, does not qualify as an affiliate cannot be accepted by this court. The said Bulaki Das Bhaya and his family members directly or indirectly control and manage SSMIL and CNE Limited, and the latter two companies function as per the wishes and dictates of Bulaki Das.
The family members come for the first time here.
Yes. And my lord, it's his family. His family members, because they are the shareholders in BG Chemicals. My lord, Bulaki Das Bhaya by himself, my lord, has a small percentage. His wife has close to, my lord, 90%.
Where? Busy.
In BG. My lord,
Busy.
so that's what I'm saying. My lord, its family members is coming in the context of BG. My lord, his brother's family members or his brothers are not included in this. So, my lord, Bulaki Das Bhaya and his family members directly or indirectly do control and manage SSSMIL and CNE Limited. And the latter two companies function as per the wishes and dictates of Bulaki Das Bhaya. This, my lord, even this, my lord, the last limb that they function, my lord, is totally, my lord, absent. Now, my lord, this court is therefore of the view that an individual or group of persons, including a family in control and management of a company, upon lifting of its corporate veil, can definitely qualify as an affiliate within the meaning. Now, my lord, here, if I'm right in my submission, my lord, the explanation, my lord, to, my lord, the 5th and 7th schedule as to what an affiliate is. My lord, kindly have a look. My lord, in my first submission is, it, my lord, has to be a juristic entity. Second, my lord, it has to be in one group of companies. And third, my lord, it must have a parent company. My lord, kindly take explanation 2 to the 5th schedule. My lord, 5th and 7th are the same. My lord, the explanation, kindly have a look at. My lord, explanation 2.
Yes.
The term affiliate encompasses all companies in one group of companies, including the parent company. So, my lord, the parent, my lord, is, my lord, the sun, my lord, in a solar system. My lord, everything else, my lord, going around, my lord, that. My lord, our, my lord, subsidiaries, there may be sub-subsidiaries, there may be 5 tiers, there may be, my lord, several first tiers. My lord, this is, my lord, what is, my lord, contemplated. First, it has to be a juristic entity. There's no question of individuals being involved. My lord, it has to be a group of companies with a, my lord, parent company. Now, my lord, I'm buttressed, my lord, I want to buttress my argument, my lord, in this regard, by reference, my lord, to the IBA rules, my lord, the International Bar Association rules. Now, my lord, this was an organization, my lord, which was set up, my lord, in 1994. And, my lord, members of the bar and, my lord, legal practitioners globally, India had also, my lord, a fair representation. My lord, they became members. And, my lord, there was, my lord, at that point of time, my lord, of Philip being given, my lord, to, my lord, alternate dispute resolution, my lord, mechanisms, my lord, for the purposes of solving commercial disputes. Saying, my lord, court should only be looking, my lord, at, my lord, rather than commercial disputes, my lord, other, my lord, disputes, my lord, which involve, my lord, more, my lord, individual rights, my lord, constitutional issues, etc. So, my lord, after 10 years, my lord, of working the alternate dispute resolution system, examining how it had worked, my lord, they framed, my lord, the 2014 regulations on, my lord, their 10th anniversary. That, my lord, was just before these. Please, I'll give it to you. I'll give you everything. What do you want? IBC?
Just for a minute.
Yeah, sure. My lord, I don't know why people get competitive.
Yes, sir.
I could be making a mistake. My learned friend has an opportunity, my lord, to tell me that.
No, sir. I just want to see one.
Oh, my lord, he needs to refresh his memory. No, my lord, let it.
No, we have got,
No, I've given a copy.
we have also
Yes.
got one. No.
Oh. Yeah, give me mine. You take this. My lord, earlier I used to be very careful handing up books to learned judges because I lost them. But some never came back.
Completely agree. Completely agree.
Now, my lord. So now, my lord, in the 10th anniversary, my lord, in 2014, they framed, my lord, a set of rules. My lord, giving guidance, my lord, on, my lord, the neutrality of, my lord, arbitrators, my lord, disclosure requirements, etc. Now, my lord, kindly take, my lord, I've only got the extracts. If your lordship wants, my lord, I can get.
IBA guidelines.
Let me do it. If I can't find it, I'll ask you. My lord, the IBA guidelines. My lord, of 2014. Give a copy to the other side. My lord, the process of arbitration, my lord, waiver, etc., all there. My lord, the relevant portion, my lord, is, my lord, if your lordship kindly takes page 4, my lord, of that, the page numbers at the bottom.
Yes.
My lord, the heading is Part 1, General Standards regarding impartiality,
Yes.
independence and disclosures. Then, my lord, kindly come, my lord, under this, my lord, chapter, we come to, after this chapter, my lord, we come to Part 2, which is practical application of the general standards. Lordship has that. Now, my lord, they prepare.
No, where is that?
Page, sorry, my lord, page 70. Page 70. Bottom, my lord, is.
Yes, please. Yes.
Now, my lord, your lordship will find. Have a copy. No, you have one copy.
Yes.
Page 17. My lord, it talks about red list, orange list, my lord, non-waivable red list, etc. Then kindly come, my lord, to page, my lord, after, my lord, all this, kindly come to page 21.
Yes.
My lord, it says, my lord, kindly see the 2 footnotes. Throughout the application list, the term close family member refers to a spouse, sibling, child, parent, or life partner, in addition to any other family member with whom a close relationship exists. So, my lord, brothers, etc., don't, but my lord, we are not concerned with that.
Close is not used here.
Yes.
Yes.
Now, my lord, kindly come to know 4 is what is important. Throughout the application list, the term affiliate encompasses all companies in a group of companies, including the parent company. Identical language to explanation 2.
Yes.
Now, my lord, this has been explained, my lord, in HRD. Now, my lord, I want to show your lordships, my lord, HRD.
2018-12 is
My lord, this is, my lord, reported in 2018.
twelve is
12 Supreme Court cases, 471. Now, my lord, one of the issues, my lord, in this case, my lord, had to do with, my lord, Justice Lahoti, my lord, was one of the arbitrators. He had given an opinion, my lord, to Gale, my lord, in a totally unrelated matter. That was the only opinion, my lord, he had given. My lord, it was not a case of, my lord, him always, my lord, giving, my lord, legal opinions to Gale. That was one of, my lord, legal opinion on an unrelated matter. My lord, his, my lord, appointment and continuance as arbitrator, my lord, was challenged on the ground that he, my lord, fell foul, my lord, of, my lord, the my lord, grounds mentioned in, my lord, Schedule 5. This was, my lord, one of the issues. There was also, my lord, Mr. Dholakia, my lord, issue, my lord, was also, my lord, involved here. Now, my lord, kindly come to, my lord, where is the Law Commission? My lord, paragraph 11 is, my lord, what is important.
Yes.
My lord, paragraph 11 itself, my lord, shows, my lord, how, my lord, matters were borrowed, my lord, from, my lord, IBA. Kindly see, my lord. Placetum E.
Yes.
Unlike the scheme contained in the IBI guidelines, where there is a non-waivable red list, parties may, subsequent to disputes having arisen between them, waive the applicability of the items contained in the 7th schedule by an agreement in writing. The 5th, 6th, and 7th schedules are important for determination of the present disputes and are set out with the corresponding provisions of the IBA guidelines hereunder. Now, my lord, 5th schedule, my lord, it's IBA guidelines, my lord, it's matched right through, my lord. Then
Yes.
6th schedule and 7th schedule, my lord, is then set out. 7th and 5th, my lord, are almost identical. My lord, there's, in fact, my lord, 7th doesn't have 20 of, my lord, schedule 5. But, my lord, this is how, my lord. Then, my lord, the Law Commission report, my lord, is discussed. And ultimately, my lord, kindly come to para 14.
Yes.
At, my lord, page 490.
Right.
The enumeration of grounds given in the 5th and 7th schedules have been taken from the IBA guidelines, particularly from the red and orange list thereof. The aforesaid guidelines consist of 3 lists. The red list, consisting of non-waivable and waivable, covers situations which are more serious and serious, the more serious objections being non-waivable. The orange list, on the other hand, is a list of situations that may give rise to doubts as to arbitrators' impartiality or independence, as a consequence of which the arbitrator has a duty to disclose. The green list is a list of situations where no actual conflict of interest exists from an objective point of view, as a result of which the arbitrator has no duty of disclosure. These guidelines were first introduced in 2004 and thereafter been amended. And after seeing the experience of arbitration worldwide, in part 1 thereof, general standards regarding impartiality, independence, disclosure are set out. Now, my lord, general guidelines. Then, my lord, Vostra plane is, my lord, considered. Now, my lord, kindly come to My lord, paragraph 18. My lord, 17 actually, my lord. It will be noticed that items 1 to 19 of the fifth schedule are identical with the aforesaid items in the seventh schedule. The only reason that these items also appear in the fifth schedule is for purposes of disclosure by the arbitrator, as unless the proposed arbitrator discloses in writing his involvement in terms of sections 1 to 34 of fifth schedule, such disclosure would be lacking, in which case parties would be put at a disadvantage as such information is within personal knowledge. It is for this reason that it appears that items 1 to 19 also appear in the fifth schedule. Then, my lord, Diwan submissions, my lord, Mr. Diwan submissions are recorded. Kindly come to para 20. However, to accede to Shri Diwan's submission that because the grounds for challenge have been narrowed as aforesaid, my lord, the 2015 amendment, my lord, had, my lord, amendment to section 34 and, my lord, introduced these. Now it says, has been narrowed as aforesaid, we must construe items in fifth and seventh schedule in the most expansive manner so that the remotest likelihood of bias gets removed is not an acceptable way of interpreting the schedules. Now, my lord, as has been pointed out by us herein before, the items contained in the schedules owe their origin to the IBA guidelines, which are to be construed in the light of the general principles contained therein, that every arbitrator shall be impartial and independent of the parties at the time of accepting his/her appointment. Doubts as to the above are only justifiable if a reasonable third person having knowledge of the relevant facts, kindly, well, let's see the test being on. If a reasonable third person having knowledge of the relevant facts and circumstances would reach the conclusion that there is a likelihood that the arbitrator may be influenced by factors other than the merits of the case in reaching his or her decision. Well, this is the general standard, my lord, which has to be borne in mind when interpreting. Now, my lord, this test requires taking a broad, commonsensical approach to the items stated in the fifth and seventh schedule. This approach would therefore require a fair construction of the words used therein, neither tending to enlarge or restrict them unduly. It is with these prefatory remarks that we proceed to deal with the argument of both sides in construing the language of the section. So, my lord, this is, my lord, a guide to, my lord, the interpretation. My lord, kindly keep this case aside. I'm going to come back to it regarding the grounds also. My lord, it can't be, my lord, most expensive. My lord, one cannot ignore the language. My lord, keeping in mind, my lord, what, my lord? Now, my lord, what happens? And this is, my lord, drawn from IBA guidelines, which, my lord, looked at affiliate, my lord, from the in the context it appears, my lord, of a juristic entity.
But Mr. Mukherjee, with utmost respect to the obviously Justice Nariman, but here, can you transpose a different, it's not a statute, a different guidelines into this just because a section of that was borrowed? The other part was not borrowed. So can that be a valid test? I mean, we cannot question a Supreme Court judgment, but we are just asking, can that be a valid test? Because consciously legislature did not adopt a portion and adopted a particular portion. So on the anvil of that, can this be tested? This is one aspect, and the other is because justice must not only be done but also appear to be done. Should the widest amplitude should be given to the? I mean, this interpretation is merely on the premise of IBA, a part of which was taken, leaving out the other part, which other part was taken into consideration by the Supreme Court.
Now, my
So
lord,
that's one thing which is just irking us. I mean, in a sense, that can you just, because uncitral model law.
no, the other is there as explanation one.
Acha.
I want
So
to
the
show your lordship.
other is also there.
Yes.
General principles.
Yes, my lord, that is also there. Now, my lord,
The expression
yes,
one is that
yes,
those.
my lord, first is kindly take explanation one. I showed your lordship two because that is two.
Yes, that is it.
only
That
the,
has been.
is the
Yes,
subject matter here.
yes, yes.
Now, my lord, one is the term close family member refers to a spouse, sibling, child, parent, or life partner.
No, we are meaning that the general principles have been considered here. of IBA guidelines.
Yes.
General principles do not form a part of this either of the expansions.
No, no.
This is on the test is on the basis of general principles
Yes.
because it's anyway it's a interpretation of the Supreme Court
Correct.
is binding on us.
No,
Let us
my lord.
leave it at that.
No, my lord, let's put it this way. My lord, why general principles? My lord, it was, my lord, part of, my lord, IBA, and it's also, my lord, part of, my lord, this decision. Now, my lord, kindly see.
Yes, we are so cautious, Mr. Mukherjee, you can obviously understand.
I know.
There's a question of, no, not for that only, because there's a question of reverse bias also. We may
Yes.
try to prove ourselves,
Correct.
not us, the arbitrator here,
Correct.
prove that I am fair, and so, I mean, turning down the prayer of a party which otherwise should have won it.
My lord, I
Just to
found-
show that
my
I
lord,
have,
to tell your lordship, my lord, be candid. My lord, some, my lord, learned judges, my lord, who I knew well at the bar, my lord, I should probably not have appeared, my lord, in the court.
yes, right.
I should, my lord, that should have been the right
We are
decision.
always on that
Yes, because,
drive
my lord,
to show
on
the
every
proof that,
day,
yes,
my lord, that I had a matter,
yes.
I was number one, most tense. Most tense. That's knowing the judge, the kind of questions that would
yes,
come.
yes.
But, my lord, more than that is, my lord, questions which would have not been put to others.
Yes.
My lord is put to, my lord was being put to me, and I felt it.
Because we have to be very conscious,
Yes.
to tell you frankly, on the reverse bias.
Yes.
Because we know that we won't be biased,
Yes.
suppose. In our mind, we know.
No, no,
Whoever is the judge, he
Yeah.
knows, he or she knows
Yeah.
that I won't be biased in favor of my. But the reverse bias is the more
yes,
crucial
my lord,
test.
my lord, which, and my lord,
So that we
that
obviously tend
happened.
to prove
And, my
ourselves.
lord, at home, my lord, there was a suggestion made, why don't you just stop appearing and meet him as often as you used to meet him? Earlier, you'll be happier.
That's true, actually, in a sense. But that's
My
not
lord, that
possible.
was followed, my lord, by, my lord, Mr. Setalwad and Justice Bharucha.
Acha?
My lord, my lord, but my lord, it was reciprocated. If Justice Bharucha saw in any matter, my lord, that he had appeared in the Bombay High Court, he'd recuse himself. Straight away. It's not that, oh, now you're not appearing, I can take it up. All that didn't happen. My lord, it was reciprocated from day one. My lord, every day, till Justice Bharucha, my lord, got elevated, they used to meet for tea after court, which lasted for about 2 hours.
Oh.
And then they went home. And Mr. Setalwad was an absolutely brilliant lawyer. I've had the privilege and good fortune, my lord, of appearing against him.
Is Mr. Setalwad?
Yes.
Acha.
My lord, in a SEBI matter, a takeover matter, my lord. And my lord, the point involved was of conflict of laws.
Right.
And he was absolutely brilliant. And I can say this with confidence that I won before, my lord, the appellate tribunal. I lost in the Supreme Court ultimately because that point was not understood. My lord,
Yes.
so, my lord, I'm conscious of that. He was, my lord, I had no answer. My lord, he was absolutely brilliant. And the only problem he had was if he was asked to, my lord, after making a point, asked to repeat the point, he said, I'm only here to make it once. Either the judge gets it or I'm out. My lord, that was the only problem. But, my lord, he was, my lord, of a different level, my lord. I mean, I don't think, my lord, in the Bombay High Court, my lord, I have come across anybody who has been, my lord, so
Has been
clear,
so
my lord.
profusely praised in so many biographies and all different people.
My lord, I'm talking about, my lord, the son.
Son Setalwad.
Now, my lord, kindly, my lord, now, my lord, my lord, the portion your lordship, my lord, I'll just, my lord, since
So
your
therefore,
lordship-
this is the Supreme Court lays down, deals directly with these explanations and says that not the most expensive,
Yes.
but whatever is there.
Yes, in effect. Now, my lord, over and above that, I am not saying, my lord, that your lordship will not keep aside, my lord, the normal, my lord, principles, my lord, in interpreting, because there are guide, my lord, in aid of that. The language, my lord, of, my lord, section 12, my lord, explanation is Schedule 5 is a guide.
Yes,
the
this is a
disclosure.
statutory restriction.
Correct.
So we have to be very clear on that.
Yes.
This is not general, not the, the standard of model rule, mode of conduct of judges or something like that. So this is not the Bangalore
My lord,
Convention,
not the Bangalore.
not the Bangalore Convention. So we have to,
Speak about cases, my lord.
yes, Bangalore Convention, but Bangalore Convention is not followed anyway.
No.
So
My lord,
who
and-
follows?
My lord, the examples been set by the highest court.
Yes, highest person of the highest.
Yes, highest person. My lord, first among equals.
So Bangalore Convention, that has been given a go by in any event de facto.
Yes.
So, but
Go-
even then, this is a statutory restriction. We have to
yes,
look at the statute.
yes, yes.
Very well.
Now, my lord, in that context now, my lord, kindly take paragraph, my lord, 54, my lord, which I was
Yes.
placing. Given that the and my lord, one other thing, my lord, just to my lord, make this clear, my lord, this passage of HRT, my lord, has been considered and followed by my lord subsequent Supreme Courts as well. I can give my lord those, just not cite, my lord, I'll just
Yes,
give
yes.
the list, my lord.
If not deviated from or
Yes, my lord.
then need not repeat judgments.
Then, my lord, so my lord, now, my lord, I am, my lord, now on affiliate. My lord, the findings, my lord, arrived at, my lord, in paragraph 54. My lord, first finding, Mr. Ghosh's argument that an individual, my lord, fourth line.
Yes.
Mr. Ghosh's argument that an individual, so and so in control and management of SSMIL does not qualify as an affiliate cannot be accepted by this court. Bulakidas Bhaiya and his family members directly or indirectly do control and manage so and CNE, and the latter two companies function as per wishes and dictates of Bulakidas Bhaiya. You know, there's the greatest of respect, my lord. There is, my lord, no evidence to that effect. My lord, none has been, my lord, referred to, my lord, in, my lord, the findings.
So on fact as well as on law.
Correct. My lord, I am first, my lord, on facts. I have to, my lord, unless, my lord, I can
Satisfy the conscience of the.
yes, my lord, facts is most important.
Yes.
Now, my lord, that's how I look at it. My lord, law, my lord, will take its course. My lord, facts are, my lord, what I am. Latter two companies function as per the wishes and dictates of Bulakidas Bhaiya. There is nothing. This court is therefore of the view that as an individual or a group of persons, including a family in control and management, upon lifting of its corporate bail, can definitely. So individuals can qualify. You know, that, my lord, is true. In the teeth of, my lord, the, my lord, statutory, my lord, explanation. Completely. Now, my lord, if affiliate falls off, my lord, really, my lord, my submission still remains what it was on the first day. My lord, the entire case falls. Entire case falls. Because, my lord, most of the grounds in Schedule 5 and 7, my lord, either deal with, my lord, the parties, a relationship with the parties, or, my lord, the subject matter of the dispute. Now, my lord, kindly have a look, my lord, at the next, my lord, heading, which is, my lord, has the arbitrator rendered himself ineligible under section 12, 2 and 5 and grounds 2, 11, 15 and 20 of the 5th schedule and grounds 2, 8 and 15th of the 7th schedule of the Act of 1996. My lord, this is, my lord, the issue, my lord, which is, my lord, being examined. And, my lord, it goes on, my lord, till, my lord, the very end, my lord, starting from para 55. But I'm not going to trouble you a lot. This is where, my lord, I was really, my lord, dealing with, my lord, this, my lord, issue. I had, my lord, placed, my lord, up to, my lord, I had quoted, my lord, the relevant passage from, my lord, Vostalpine Shen GmbH, which is at para 64, page 1594, 1595. Now, my lord, kindly just, I'm not going to cite this, but, my lord, kindly take page 1595, my lord, where para 25 of this decision is set out. And, my lord, kindly see my lord, the sentence starting about 8 lines from the start, likewise.
Likewise,
The
yes.
7th schedule mentions those circumstances which would attract the provisions of subsection 5 and nullify any prior agreement. In the context of this case, it is relevant to mention that only if an arbitrator is an employee, a consultant, an advisor, or has any past or present business relationship with a party, he is rendered ineligible to act as an arbitrator. Likewise, that person is treated as incompetent to perform the role of arbitrator who is manager, director, or part of the management, or has a single controlling influence in an affiliate. My lord, the language itself shows it has to be, my lord, a juristic entity.
If it is to be at the biological entity level,
Yeah.
then it has to be with the party.
Correct.
And if it's affiliate, then it has
Has
to be
to- I'm
juristic.
grateful. I'm grateful.
That is your
Yes.
distinction you're
Yeah.
drawing.
Now, my lord, and if the affiliate is directly involved in the matters in dispute in the arbitration, likewise, persons who regularly advise the appointing party or affiliate of the appointing party are incapacitated. A comprehensive list and schedule and admittedly empaneled are not covered by any. Now, my lord, Himadri, I'm not troubling your lordship with. Then comes Zila Dukt. Then, my lord, this court is, however, not inclined to accept that non-disclosure by the arbitrator having represented so-and-so in the High Court during pendency would amount to fraud. I've placed this, my lord, that there is no fraud, para 68 and 69.
Yes.
And, my lord, the allegations, my lord, of corruption, fraud and bias are given up.
Hmm.
The learned judge still proceeds on the basis, look, if he was ineligible, I have to examine that. My lord, that will be my last, my lord, ground.
Hmm.
My lord, one is in law, one is in fact. And my lord, the last ground would be after these are given up, should the, my lord, court have proceeded at all in the matter.
Section 34 is there in its suo motu scope of doing anything?
Yes, there is. My lord, I'll kindly take, my lord,
Application.
section 34.
But recourse has to be taken to court.
Yes, it has to first go, my lord, to
Whether
court.
that should necessarily form a ground taken in the
No, now, my lord, kindly see 2B.
the court finds it.
Fine.
Right.
So, my lord, if all facts are there, my lord, court finds.
Itself can also.
Yes.
We are putting it against you. So,
Yes, and my lord, the court here has found
Yes.
that there is no fraud.
but at least the materials have to be there. The pleadings,
Correct,
some
correct.
pleadings-
All it has to appear, my lord, from my lord.
Yes, definitely. That has to be there.
Yes. Now, my lord,
So court might have gone into that question of
disclosure.
bias disclosure. Yes.
Bias as alleged, certainly not, because it's being given up. Fraud is being given up. Corruption is being given up.
Even if they give up, whether the court can under 34(2)(b.
My lord, that's the issue I will address, my lord, last. There was really no need, my lord, to go into that.
Right.
Now, my lord, here, kindly come straight away, my lord, to para, my lord, I had shown your lordship, my lord, para 59
Yes.
earlier. My lord, it's at page 1593.
Yes.
My lord, one of the arguments advanced was that Bagri knew that we used to appear for SSMI. It did not. So, my lord, the learned judge says what is important is whether the same would attract ineligibility is what is being decided. Now, my lord, after Himadri chemicals, etc., my lord, 68, 69, my lord, is my lord given up. Kindly come to para 70.
Yes.
Now, my lord, it is, however, necessary to consider whether the arbitrator representing SSIML, an affiliate of CN, my lord, and Bulaki Das Bhaya during pendency would either constitute bias or act likely to suggest or indicate bias.
It is a second degree legal fiction,
Correct,
if you may say that.
correct. That's what's happened. My lord. My lord, one thing might be going on in the mind. My lord, it could get, my lord, it's possible, my lord, nobody is infallible, my lord.
No.
There can be, my lord, this. So, my lord, but this, my lord, when tested, my lord, being tested in the appellate jurisdiction, my lord, I have to take this point, my lord, that this is really, there's no basis for this. That's of this, my lord, factual, my lord, situation. And what I,
Yes, yes.
and my lord, what I forgot to show to your lordship, my lord, I should show now itself, my lord, apropos affiliate, my lord, individuals were not, my lord, included. Now, my lord, kindly take, my lord, the 2024, my lord, IBA, my lord, rules.
Yes.
My lord, page 15 of that. My lord, that's 2014. 10 years later, my lord, my lord,
Oh, what version?
my lord, page 15.
Yes.
My lord, kindly see the footnote.
Mm.
Throughout the application list, the term affiliate encompasses all companies in a group of companies, including the parent company and or an individual having a controlling influence on whom? On the party in the arbitration and or any person or entity over which a party has a controlling influence. My lord, individuals come in. Even then it would not apply, my lord, I can show that. But my lord, this is, my lord, what is important.
Then this judgment of Justice Nariman has to be read in this context.
No. This is subsequent.
Premise of that judgment was this, the previous version of IBA.
Yes, and that's where it's remained. The legislature hasn't made that change.
Our law has not. Right.
Our law has not changed.
And that by specific contrast,
Correct.
so
That's, my lord, my,
the other way around.
yes, other way around.
Other way. All right.
Now, my lord, kindly go back to, my lord, the judgment,
Yes.
my lord, which is, my lord, কোথায় হারিয়ে যাচ্ছে?
Paragraph 70.
Yes. Now, my lord, then, my lord, kindly take, my lord, paragraph 73.
Yes.
And this is very important. In the backdrop of the above, this court notices that having once made a disclosure in the first sitting that the arbitrator and his family members were connected with and represented the Bhaiya group in CS 344 of 2015, the learned arbitrator was obliged not to represent them any further. My lord, this is, my lord, the finding. But, my lord, the disclosure, my lord, has not been correctly paraphrased. Now, kindly come to paragraph 12, my lord, of the judgment. My lord, there were two disclosures, my lord, made. My lord, they are quoted. My lord, that's in the earlier volume, volume 12, page 1573. My lord, page 1573, 2.1. My lord, this is, my lord, 10th August 2014. My lord, disclosure.
Yes.
And this is, my lord, prior to the amendment. So, my lord, after the amendment, my lord, my submission was it's only the schedules, my lord, which are applicable for the continued duty of disclosure. Nothing else. Now, my lord, as it fell from your lordship, my lord, your lordship wouldn't take up matters, my lord, totally unrelated matters, my lord, if your lordship had, my lord, appeared for, my lord,
Yes.
one my lord, client.
Yes.
My lord, there's really nothing wrong in doing that. My lord, many
That's
people do that. So
someone's
that's,
personal-
so my lord, here now, my first submission is, he's not bound, my lord, any further by this disclosure, what he had said. It is the continual, my lord, disclosure is now Schedule 5 and Schedule 7. But, my lord, even if he was bound by this, kindly see, my lord, what the disclosure was. Para 2.1. At the outset, the arbitrator informed the parties that he had professionally been engaged several years ago as counsel to appear for Mr. Bulakidas Bhaiya, one of the claimants in this proceeding, or by companies within his management and control in certain earlier legal proceedings with regard to which Sri Bhaiya had attended the conferences and had occasion to confer with and meet the arbitrator. So, my lord, as far as the arbitrator was concerned, his disclosure is, I had appeared for Bhaiya in the past. Second, I had also appeared for companies under the control and management of Bhaiya, where Bhaiya would attend the conferences. So really it's a disclosure regarding his relationship with Bhaiya. In effect. But my lord, let's take it, my lord, expand it. My lord, that it
And companies
and
within his
companies
management.
under his control.
Yes,
This
sir.
is, my lord, these are, my lord, the two, my lord, disclosures he's making. But family members, my lord, appearing in all these matters is not there. What is there, my lord, is
The family
arbitrator
next-
further informed.
Next sentence, family
Correct.
members.
Correct. So, my lord, it is only with regard to the party here. Kindly see. The arbitrator further informed the parties that his son so-and-so had apparently also appeared for the claimants in interlocutory proceedings arising out of. As I said, my lord, I lost a junior, my lord, in the matter. And my lord, many years later, my lord, I think, my lord, he was, my lord, elevated. But, my lord, this was, my lord, the disclosure made. Now, my lord, kindly come. In 2014, my lord, when the old regime.
But he appeared for the claimants.
Correct. That's what I'm saying. My lord, it has not been correctly, my lord, quoted, my lord, in paragraph 73.
Each one, minutes.
Minutes are there. He's quoted it. My lord, kindly see para 73.
Yes. Yes. Right.
Was connected with and represented by a group. That's not the. Now, my lord, assuming, my lord, what is, my lord, said here, my lord, in the judgment, my lord, is a correct proposition of law. Having made that representation, my lord, he should not have appeared, my lord, for Bhaiya or, my lord, any companies under his control. Now, my lord, it's nobody's case that, my lord, the arbitrator, my lord, appeared for Bhaiya. After this, my lord, disclosure.
Acha.
After this disclosure. It's nobody's case. The next thing is, did he appear for a company which is under the control of Bhaiya? My lord, he appeared for SSMIL, where, my lord, Bhaiya was not in control. So if he's even held to this, that he could not have appeared, he could not have.
He did not appear after this, after taking up this
Yes.
assignment, he did not appear for Bhaiya or BG or any of the parties.
Or any, correct. He appeared for no party. My lord, his was
So only he
claimant,
appeared for
SSMIL. That's
Triple
all.
S, yes. All right.
Which, my lord, from private had already been converted into a public.
Yes, that is. So we'll just come back.
Yes.
Yes, please.
Now, my lord, at page 1600, my lord, kindly see.
Yes.
My lord, paragraph 74.
74.
In
Right.
addition to the aforesaid breach, the arbitrator also suppressed and failed to disclose before the parties to arbitration that he appeared for SSSMIL Bhaiya Group. The chain of events between would definitely give rise to a likelihood or danger that arbitrator may have allowed himself to have been compromised and consequently raise justifiable doubts as regards his independence. This court sees the above in no uncertain terms, as any reasonable man in the facts of the case would also see. There is clear breach and or infraction of the principle that justice must not only be done.
Mr. Moji, what is this SSMIL Bhaiya Group? I mean, in the SSMIL litigation, SSMIL as a company
NPT,
was,
yeah.
there was no control clash
No, it's a commercial dispute with SM Chemicals,
with someone else.
someone else. Then my lord 75, of course, my lord, cannot enter into the mind, etc.
Mhm.
And then 12.2 has to be strictly enforced, etc. And my lord, I am arguing it on the basis, my lord, that it should be strictly enforced.
Yes.
My lord, not. Now, my lord, all the judgments, my lord, on my lord, what is bias, starting with my lord Ranjit Thakur, etc. And then, my lord, para 85 is the continuing obligation. Then, my lord, we have ineligibility cases, my lord, being cited. My lord, Sama, my lord, my lord, amendment, Sama post.
Mhm.
And then, my lord, there is AT&T Corporation, my lord, an English case, my lord, which was cited, the Court of Appeal by Mr. Ghosh, my lord, which was distinguished, your lordship will find in para 95. At page, my lord, 1612. This court is of the view that the conclusion of the Court of Appeals in the said case, upholding the mandate of the arbitrator after setting aside the views of the High Court, may not apply to a case where there are codified rules like sections 12 and 5th and 7th schedules to the Act of 1996. And my lord, 97 is, however, this court finds that danger and probability of bias test more acceptable as opposed to likelihood and possibility, even if you were to apply the real danger of bias and probability thereof test, arbitrator's conduct would certainly fall foul within so and so. This is the finding, my lord, of 2, 8, 2, 11, 15 and 20 and grounds 2, 8 and 15. Now, my lord, kindly have a look at these, my lord, because later, my lord, ground 2 is dropped by the, my lord,
Yes.
court. But, my lord, kindly have a look at all, my lord. My lord, kindly take the 5th schedule.
Yes.
The following grounds give rise to justifiable doubts as to the independence or impartiality of arbitrators. Now, kindly see the first heading. Arbitrator's relationship with the parties or counsel. So, my lord, kindly take 2. My lord, I would request your lordship also to look at 1, which was, my lord, considered, my lord, in HRD as well. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with a party. My lord, here, of course, that's not been pressed, but I'm just saying HRD concerned that. So, my lord, I am, my lord, just showing your lordship. Now, kindly have a look at 2. The arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. This is not the case. Case, my lord, is of counsel, had appeared, my lord, in a case where he would have had conferences with, my lord, Bhaiya attending on behalf of, my lord, SSSMI. Now, my lord, arbitrator currently represents or advises one of the parties, my lord, which is, my lord, clearly not the case, or an affiliate of one of the parties. If I'm right in my submission, my lord, that this is, my lord, not an affiliate, my lord, whether, my lord, I don't need to even address, my lord, represents or advises. What kind of advice or representation was this? Because, my lord, that is also discussed in HRD, which I'll come to. It has to be, my lord, an advisor like this, my lord, is a regular employment. My lord, that's what, my lord, HRD says. Now, my lord, kindly come to 11. That's the other one, my lord. Is a legal representative of an entity that is a party in the arbitration. My lord, clearly, my lord, not my lord. Then, my lord, kindly come to 15. The arbitrator has given legal advice or provided an expert opinion on what? On the dispute. My lord, clearly not. That's not the case. And, my lord, in any event, my lord, nothing has been done with a party or an affiliate. Now, kindly come to 20. Now, kindly see the heading. Previous services for one of the parties or other involvement in the case. The arbitrator has within the past 3 years served as counsel for one of the parties. I pause here. Well, clearly not counsel for one of the parties or an affiliate of one of the parties. Here also, my lord, if I'm right in my submission, this or has previously advised or been consulted by the party or an affiliate of the party making the appointment in an unrelated matter. So he ought to have been consulted or advised in an unrelated matter by the party or an affiliate of the party. No party has, and, my lord, here not an affiliate. But the arbitrator and the party or the affiliate of the party have no ongoing relationship. So, my lord, in my respectful submission, my lord, on the face of it, my lord, none of the grounds, my lord, apply.
Ongoing relationship need not be professional.
Yes. Then, my lord, 7 schedule. Kindly take 2, my lord. Ground 2, 8 and 15.
Yes.
The arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. This is identical to 2 of the 5th schedule. Then, my lord, 8. The arbitrator regularly advises the appointing party or an affiliate of the appointing party, even though neither the arbitrator nor his or her firm derives a significant financial income therefrom. Again, my lord, if it has not, my lord, advised, my lord, the appointing party. My lord, in fact, my lord, here there was no appointing party. It was court appointed.
Yes. Yes.
Or an affiliate of the appointing party, even though neither the arbitrator nor his or her firm derives a significant. And, my lord, 15, the arbitrator has given legal advice or provided an expert opinion on the dispute to a party.
So at best 2. If affiliate was your point was to be.
No, 2, my lord, will never happen. I will show, my lord, that why, my lord, in HRD.
No, affiliate unless.
Even, my lord, if it's affiliate, my lord, the advice is not a one-off advice.
No, currently represents or
Advises one of the parties.
8 is regularly.
Yes. Now, my lord, kindly have a look.
If it does not take money, then regularly.
Yes.
And if it takes money, then
My lord,
professional would do.
kindly have a look at, my lord, HRD, my lord.
Yes.
My lord, which I had handed up. My lord,
Yes, yes, it's with us.
yes. Where is it? Now, my lord, kindly come to para 22 of HRD.
Right.
Shri Diwan has pressed before us that since on a legal issue between GAIL and another public sector undertaking, an opinion has been given by Justice Lahoti to GAIL in the year 2014, which had no concern with respect to the present matter, he would stand disqualified under item 1 of the 7th schedule. Items 8 and 15 were also faintly argued as interdicting Justice Lahoti's appointment. Item 8 would have no application as it is nobody's case that Justice Lahoti regularly advises the respondent. My lord, that's what your lordship, my lord, pointed out. Now, and item 15 cannot apply as no legal opinion qua the dispute at hand was ever given. On reading item 1 of the 7th schedule, it is clear that the item deals with business relationships. The words any other show that first part of item 1 also confines advisor to a business relationship. The arbitrator must therefore be an advisor insofar as it concerns the business of a party. Howsoever widely construed, it is very difficult to state that a professional relationship is equal to the business relationship, as in its widest sense, it would include commercial relationships of all kinds, but would not include legal advice given. This becomes clear if it is read along with 2, 8, 14 and 15, the last item specifically dealing with legal advice. Now, my lord, under items 2, 8 and 14, sorry, my lord,
Yes.
under items 2, 8 and 14, advice given need not be advice relating to business, but can be advice of any kind. The importance of contrasting item 1 with 2, 8 and 14 is the arbitrator should be a regular advisor under items 2, 8 and 14 to one of the parties or the appointing party or an affiliate thereof, as the case may be.
It's a present continuing tense. I mean,
Correct. Because if your lordship sees,
currently
represents or advises.
or advises,
Yes.
not a one-off situation. Although regularly is not used in context
Correct.
to 8.
Correct.
All right.
Now, my lord, though the word regularly is missing, kindly see,
Oh, after that.
is missing from items 1 and 2, it is clear that the arbitrator, if he is an advisor in the sense of being a person who has a business relationship in item 1, or a person who currently advises or his affiliates in item 2, connotes some degree of regularity in both items.
And the tense is very important.
Correct.
So that you don't get tensed.
Correct. The advice given under any of these items cannot possibly be one opinion given by a retired judge on a professional basis at arm's length. Something more is required, which is the element of being connected in an which is an element of being connected in an advisory capacity with a party. Some element, my lord, of regularity is required.
But we cannot take it to the level of a retainer sort of. Because that's not used in.
My lord, retainer is not, but my lord,
This
we are
is-
regularly going to, my lord, many persons have a retainer and are happy if they are not engaged at all. I my lord, prefer those. Now, my lord. So, my lord, I say, well, you don't want me to appear, I'm happy. I don't want to advise, I'm happy. But just ensure that. So, my lord, what we today term, my lord, negative retainers.
Yes.
So, my lord, no, I don't say, my lord, that it has to be
But
taken.
yes,
Yes. But, my lord,
Advices.
yes.
Currently advices.
Yes.
Right.
So, my lord, there has to be an element of regularity. And, my lord, maybe on more than one issue.
Otherwise, the wording could have been represented or advised after
Correct,
taking
correct,
the
correct, correct,
assignment.
correct. So, my lord, 2 also goes out.
Who is the best ground they have?
Could have,
apparently?
could have.
Very
Goes out, my lord, completely. So, my lord, in my respectful submission, my lord,
Yes.
the factual basis itself, my lord, is not there. Now, my lord, I had said, my lord, that there be. My lord, I've got Clemens and Clemens, which your lordship wanted.
Yes, yes. Just
My lord,
please-
I think, my lord, on the case, my lord, ArcelorMittal covers it, my lord, clearly.
Yes.
My lord, proactive, negative. My lord, this is, my lord.
ArcelorMittal actually covers it,
Yes, my lord,
but this is for us, not for you.
yes, my lord, yeah. I'm not
Yes.
citing it. No, no, I'm not citing it. My lord, this was an oppression case. My lord, where, my lord, the niece would have lost the right, my lord, to veto a special resolution.
Yes.
Court held.
But this is for you. We may rely on this also. So we are putting you on notice,
Yes,
even
yes,
if he's not formally citing.
Yes, yes, yes. My lord,
But
I
we-
noted it down. Yes.
Yes. Right.
Give him a copy. Give him a copy. My markings are there, huh? Don't. My lord,
Yes.
this was a case, my lord. It was a civil suit
Hmm.
where, my lord, a resolution was being adopted, my lord, for allotment of more shares to, my lord, employees. Aunt was in control, wanted, my lord, to keep the employees happy, my lord, an employee stock option really, my lord, and which would, my lord, diversify, my lord, the shareholding. The niece realized that if this happens, my lord, she had a right of first refusal to, my lord, purchase the aunt shares that could be lost. And second, my lord, her negative control of, my lord, blocking a special resolution. So there'd be more shareholders, the shareholding would fall below 25. So, my lord, a suit was filed complaining of oppression.
So she'll be losing on the percentage.
Correct. So, my lord, her shareholder right, my lord, was being affected. My lord, it came down to below 25. So, my lord, she could not veto or, my lord, block a special resolution. That's the language used, my lord, and which we, my lord, have, my lord, referred to as negative control, my lord, while arguing, my lord, quite often, and then there are cases to that effect. But, my lord, I think
Probably
ArcelorMittal,
ArcelorMittal is
yes, my
sufficient.
lord, it's Supreme Court on that, my
Yes,
lord,
yes,
which,
yes.
my lord, makes it very clear. Do we want
So
to
need
say-
not go into this at length.
No, I'm not.
I will just keep
And,
it
my
at
lord,
this.
the other one, my lord, was Vodafone that the job chai will
Vodafone এটা open and build up
Birla's the one.
130.
And, my lord, judgment, my lord, all of us are familiar with, my lord, is, my lord, the decision, my lord, in the decision of 24th, my lord, no, not 14th December 23, my lord. My lord, the issues, my lord, in, my lord, the what we refer to, my lord, as the Lodha Birla matter, my lord.
Oh.
My lord. My lord, your lordship probably has.
Own our own
No,
sins.
my lord, seven or eight copies. My lord, considering the matters which have been coming up. My lord, all the assigned matters, my lord, the appeals.
This is pure karma
Yeah.
for us.
No, from my lord, I am having to cite it, my lord, either for or against.
Yes,
my lord,
right.
in different matters.
We should seriously shift to paperless courts.
Yes.
We should seriously. We should, don't know whether when it will happen or whether it will happen.
Citation nahi, Calcutta,
So decide.
no copy, giving a copy.
You can give us the paragraphs.
Yes, my lord, para 103 and my lord 130 and 131.
130?
130 and 131.
130.
My lord, 103 are the issues.
Right.
My lord, extent of PDB estate, only shares or controlling interest.
On that controlling shares.
Controlling interest meaning whether the issue of extent of so and so barred by res judicata.
Yes. Yes.
And my lord, if your lordship sees, my lord, para, my lord, this was the issue.
Right.
And para 130 and 131, which are, my lord, page
57.
2. Yes. My lord,
Got it.
kindly have a look.
Yes.
Controlling interest can only mean the incidental rights, including voting rights, rights of participation in shareholder meetings and other decisions which PB would have had by virtue of her shareholding in the respective company.
Yes.
My lord, Vodafone was relied on. I
Hmm.
have it here, but I'm not citing it, my lord. That's also a lengthy judgment, my lord. And my lord, your lordships will find ArcelorMittal has also been referred to,
Mhm.
but in a different, my lord.
Mixed question of law and fact to the result.
And my lord, your lordships, my lord, were concerned with, my lord, the definition of control.
Mhm.
My lord, kindly come to just one portion, my lord, 10 lines above para 132. My lord, that's page, my lord, 260.
Yes.
Therefore, the bone of contention, your lordship has that, my lord, starting right-hand side, 7 lines from the top or 8 lines from the top.
Yes. Got it.
Therefore, the bone of contention is not as to whether the definition of the word control is an inclusive definition or an exhaustive definition. But what is most important to note in the definition of the word control is that there must be a right to appoint majority of directors or a right to control the management of policy decisions exercisable by a person or persons acting individually or in concert directly or indirectly, including by virtue of their shareholding or management rights or shareholders' agreements or voting rights or in any other manner. Therefore, the word right as contained in so-and-so is of utmost importance, and the definition of the word control cannot be read to mean something dehodes the existence of it.
There the context was a bit different because
Yes,
it was
but-
her charisma and her
Yeah, That's what
influence.
was argued. That's what was argued.
That was yes.
But it's all that I'm saying, my lord, 227 of Companies Act.
Yes, yes.
Was my-
That is the guiding
Yes.
principle. And the SEBI regulations.
Yes, my lord, my lord, I have enough copies of this. Otherwise, it's also cited, reported, my lord. 2023 SCC online Calcutta.
Which one?
My lord, Birla 5959.
Oh, we'll take that because easier to refer to. Can you please?
4959
2023?
SCC online Calcutta
Yes.
4959.
Thank you.
No, I think I've. Because it's on a preliminary issue. Oh, yes, the third, my lord, the last point. My lord, it was decided and not preliminary, the 34.
Oh,
So, my lord, if I cross this hurdle, then my lord, the
decided
34.
on a.
My lord, I had shown that judgment, my lord, the interim orders passed in this matter.
Oh, just please show us again once more.
My lord, your lordship will find that. Where's your, my lord, my lord, page 1729. Which volume?
Volume 14 হবে ওইটাকে দিয়ে রাখো
My lord, kindly see the order, my lord, of 14 March 2023.
yes.
This court has indicated to counsel that preliminary question of the end of mandate of so-and-so for having appeared for an alleged sister concern of the award holder during the pendency, as argued in aid of so is also a preliminary issue. So substantial arguments. The preliminary question shall be heard along with the application. The exchange matters stand.
So
Counsel.
then it was a detailed hearing, full-fledged hearing.
Yes, in effect. And my lord, once they've given up, my lord, fraud, corruption, and my lord, bias, which is recorded in the order, my lord, there's really nothing in the 34.
No, but this decides the section 34 on merits. Why do you say preliminary issue?
My lord,
This says that the preliminary issue will be heard along. Acha, acha, acha.
as a preliminary issue in the
In
application
the section 34,
as well.
what was the preliminary issue for a sister concern?
My lord, kindly, my lord,
That
my
was the only
learned
ground.
junior Mr. Ghosh.
Yes, Mr.
That's
Ghosh, you are there.
When they moved the section 36, they
Yes.
didn't want to put in their 50 crores. The
Right,
appeal was against
right,
them.
right.
They pleaded fraud and corruption because that was the only unconditional leave. Then the arguments were made. Then I started arguments. Your lordship will see my arguments. It's all no particulars of fraud, etc. Then while I was arguing, he said, I'm giving up the question of fraud.
Acha.
And then the learned judge thought about it and came back one day and said, no, it'll be the same issue. I'll have to decide in the 34. So basically, they got away without depositing the money also.
But by the impugned
how-
judgment, 34 itself was taken up.
Yes, 34.
Full-fledged.
Because there's an earlier judgment, page what the-
Plus, there is just one.
1566.
Let Mr. Ghosh submit and
1566. Your lordship will see that's the 7th February order, where he says this was the matter appeared in the list, and the learned judge just said that I'm going to take up the 34 first, without hearing the 36.
But
Completion.
34 was taken up
Yes.
on merits. I mean, full.
Yes, while the 36 was going on, which was not decided.
So then it's not
So
a
your lordship
preliminary
sees this
question.
order 1566.
Yes, 1566.
Yes, so he says that
Here the
is
application. under section-
inclined to hear the application under section 34.
So it was a full-fledged hearing as far as the 34 was concerned.
Yes, only on this point. Then he says preliminary issue.
He does not say. He says preliminary issue.
Yes.
First, he says preliminary issue of section 34 will be heard along with 36.
Preliminary.
But then this 1566, he says,
156 is earlier. He says, I will hear the
Achha.
34.
14 March comes later, my lord.
what is the
Then
preliminary
14th
issue?
March comes.
Has he formulated any issue in the impugned judgment? We don't see
Whether
any
it's
preliminary issue.
illegible.
That was
Yes.
the entire ground of challenge.
It's one of the grounds he's just picked
Correct,
up and
correct.
said, I will hear this ground.
But there is no other ground. If they give up fraud and
Yes, there's nothing.
Maybe it's some
On merit,
perversity and
Mr.
on
Grimal,
merit, yes, may I clarify, my lords? The one issue that the honorable judge has decided is the issue regarding the eligibility of the arbitrator.
right,
Now, on that basis, I have been successful in my section 34 petition. Now,
Right.
if that issue finds favor with your lordship, then of course the award will
Yes,
not
yes.
sort of come into force. But assuming the worst case, assuming I was to lose that
other
issue,
issues have to be gone into.
yes, on the merits, because I have
That
challenges
is
to
what
the other.
Mr. Mukherjee and Mr. Ghosh are also saying. Very good.
Absolutely.
So we are
Absolutely.
agreed on that.
last but the pull.
Get it.
Last conclusion in one more.
You wanted to add something more on
Yes,
this?
my lord, just, my lord,
Clarified.
my lord, page 1 minute.
106.
My lord, only two other portions of the order. My lord, Mr. Ghosh is right. I should, my lord, show that. My
The
lord,
order is impugned.
impugned order, my lord. Wait, your wait. My lord, paragraph, my lord. 102, 106, 1617. My lord, volume 13.
Yes. Yes.
My lord, one need not also enter into the merits of an award while assessing the reasonable likelihood. What is important as to whether representation so and so on behalf of SMIL, which is a body corporate exclusively in control and management during could reasonably indicate a likelihood or dangerous. Again, my lord, the wrong, my lord, basis, my lord, on my lord facts. And my lord, then your lordship will find grounds 11, 15 and 20 of 5th schedule and ground 15 of 7th schedule, which I've dealt with. My lord, the only other point, my lord, which I had said, my lord, after having given up, my lord, 68 and 69, para 68, 69, fraud, corruption and bias, ought the learned judge, my lord, have gone ahead and my lord decided this. My lord, only one extract of, my lord, the judgment, my lord, in Volshaping, which is quoted, my lord, para 25.
HRT से yes.
My lord, show me that.
HRD judgment paragraph 16. He quotes the paragraph
Yes.
25.
My lord, kindly take, my lord, the HRD judgment again.
Paragraph 16.
My lord, where Voestalpine, Voestalpine, no, Yeah.
Volkswagen. It's pronounced the-
Voestalpine. My lord, kindly see, my lord, the quoted portion, my lord. At page 492, my lord, para 25, my lord, section 12 has been amended with objective to induce neutrality of arbitrators, namely the independence and impartiality. Amended provision is enacted to identify the circumstances which give rise to justifiable doubts about independence or impartiality of the arbitrator. If any of those circumstances mentioned therein exists, it will give rise to justifiable apprehension of bias. Now they give up the question of bias.
Yes.
My lord, that's a submission which I make, but my first two are the main, my lord, submission. There was really no need, my lord, to get into this.
Thank you.
I'm obliged.
We'll take a very short notes from you and them also.
Yes, yes.
We'll hear them first.
Yes.
Then, yes. Yes, Mr. Diwan, yes, you can start.
Mullahs, would your lordship, I will want to physically come, Mullahs. Would your lordship have it on 27th, Mullahs? I can travel on that day.
27th, we can have it, but we can start now if you want, because we have some time left.
Mullahs, unfortunately, I was thinking, I must be, Mullahs, candidate to your lordships. I thought that Mr. Mukherjee will take the day today. So,
Very
Mullahs,
well.
although I have some notes ready, I would prefer, Mullahs, that I
Very
can
well, very
physically
well.
come.
27th.
20, Mullahs, I understand that only on Wednesdays these matters are taken up.
Yes,
So,
yes.
27th is the next Wednesday. I can travel
Yes.
on that day.
Yes, Mr. Mukherjee. Well. Heard learned senior counsel appearing for the appellant. Full stop. On the prayer of learned counsel appearing for the respondent, let the matter stand postponed till August 27, 2025 for further hearing. Thank you.
I'm so deeply obliged.
My lord will fix it at 10:30. Like today.
Was it fixed today at
Yes.
10:30? Very well, at 10:30. To be taken up at 10:30.
So
Ja, बोला ना? 10:30.
Yes, grateful.
Okay.
এদের সাইটেশন গুলো একটা আলাদা করে দিতে হবে, ওদের গুলো আলাদা করে। এখন না মানে পরে। এগুলো এখানে, এটা 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 না। এটা আমার নোটটা। ওহো, আজকের নোটটা এক হয়ে ট্যাগ দিন। হ্যাঁ, আগের দিনের নোটতেই আছে। হ্যাঁ, একটার সময় একটা বেঞ্চ আছে আবার জলপাইগুড়ি, উনি এলে তারপর করবো।
Well, today Mr. Kaur was supposed to.
The other side, yes. Yes,
I'm appealing for respondent number 1, Your Lordship.
so make it not today.
Yes,
Because for the respondents,
yes, but
Respondent Institute.
yes, for the institute, he has also completed.
Yeah,
Mr. Rai has
completed, Your
completed his submission.
So who is
The
to now order?
complainant is supposed to give.
I beg to appear for the complaint. I will led by Mr. Joydeep communication legs before courtroom number 1. Like, may I pray the matter can be kept next week, my lord, next Wednesday.
Very well. You are which of the respondents?
My lord, respondent number 2 and 4, my lord,
2 and 4.
my lord.
On the prayer of learned counsel for the respondent numbers 2 and 4, let the matter stand adjourned till August 27, 2025.
Lordship.
Grateful, lordship.
Grateful. That's true is the same matter.
Do the same. Want
I am praying not today because Mr. Dotto is appearing. He is just throat problem. He has not come to court.
that matter?
In case I am not there, I may not be here, then I'll give a rejoinder on the next day. In case I will.
Yes, yes. Ask. Keep somebody, Mr. Mitra. Will just inform the other side if you have to take time on this.
Let them finish.
Right.
That thicker tendency matter.
That he got answer.
Yes, it's almost over.
Yes, Mr. Dotto is to reply. He has
Yes.
a throat problem. He has not come to court. That's the problem.
We'll keep it next Wednesday, but please make arrangements if he can't come on this.
No, he will
We
come
have
definitely.
substantially heard it.
Yes, yes.
On the prayer of learned counsel for the appellant, let the matter stand adjourned for the day. For the day means next Wednesday.
As your lordship.
None appears for the parties, adjourned for the day. এটা পাস ওভার থাক, পাস ওভার, পাস ওভার, সেম।
But I appear on behalf of the respondent in this.
Respondent. It has not yet started the matter.
No, Malaj.
None appears for the appellant at the time of call, although the respondent is represented through counsel. Let the matter stand adjourned for the day.
Grateful to your lordships.
Your Lordship, I am appearing on behalf of the petitioner. Currently, I am being led by Mr. Ratnanko Banerjee. But
Currently means previously someone else and in future someone.
right, it's Mr. Ratnanko, but he's on legs in some.
Currently he's not there. You are there. Start the matter. What is the matter about? You should have the brief.
No, sir,
What is the matter about? Tell us. If you can tell us the matter, what is the matter about, we'll release you. Otherwise, you're currently you are under our.
Just give us some time.
If you don't have the brief, you can't do that. Anyway, pass over. Pass over.
Thank you.
13, Lord, I appear for the appellant, Lord. My section 37. There is also an application, Lord, for condonation of delay.
That is appearing today, yes.
That is appearing today, Lord.
You have served on the other side.
We have served on the other side, Lord. Once your lordship has also heard it. Your lordship has heard Mr. Joydeep Kaur, Lord. He is leading me. Lordship, I don't.
No, what is the delay?
Lord, the delay is around 800 days, Lord.
They were opposing seriously.
They are opposing seriously. Section 37, Lord. We have your lordship's view was that the earlier Supreme Court's view was that the merits is not to be looked into while condoning
Now
the delay.
Justice Patwala has.
Now, my lord, there is a contrary view. Yes, so we wanted to cite that. Your lordship may kindly keeps it next week. Lord, Mr. Kaur is there.
None appears for the respondent at the time of call, although the appellant is represented through counsel. Let the matter stand adjourned for the day.
Extremely grateful, my lord.
My lord, we have for respondent KMD lordship led by Mr. Satyajit Talukdar.
Who is for the appellant?
No.
None appears for the appellant at the time of call, although the respondent KMDA is represented through counsel. Let the matter stand adjourned for the day. Pass over gulo ডেকে নিন। হ্যাঁ, আর তো হয়ে গেল সব। আর তো পাস ওভার ডাকা ছাড়া উপায়ও নেই। কোনটা ঠিক করে ডাকুন, ক্লিয়ারলি ডাকুন প্রদ্যুৎ বাবু। আবার রিপিট করুন। 8.
I appear for the respondent.
So I appear for the
We took the
petitioner.
point of maintainability of this appeal.
Pardon?
We took the point of maintainability of this appeal because your lordship had passed an order whereby lordship had extended an interim order passed by the appellate court itself by a coordinate bench. So will that have a bearing on the order, which is a common order, where they are now this appeal is from addition of parties. But the subsequent order after addition of parties for injunction, your lordship had disposed of the appeal, remanded it back after extending the interim order passed by the appellate court itself. Now, this is an appeal whereby the addition of parties, they have assailed before your lordship.
But the arguments would be different. Suppose they win this appeal, then the injunction will proceed without these parties, without you actually.
No,
some other parties.
Yes.
It will.
They are saying that they ought not to have been added.
Yes, suppose they win this appeal before us or this challenge, then the suit will proceed without them because the addition of party was in the suit itself.
Was in the suit itself.
So this is a different.
Let them argue and satisfy your lordship whether they can and whether at all addition of party via judgment to prefer an appeal before your lordship. That
But
is
if
also
it
You have challenged the addition of party.
Yes, the order is of 9th of March 2017, only one indulgence, but Mr. Chaudhary is not in town.
Mr. Jishnu Chaudhary?
Yes. But
where is the impugned order? Let us see the impugned order. 9th March order?
9th of March 2017 is the order impugned.
The suit is for?
A suit for partition.
Who was added?
My subsidiaries were added.
You on your prayer?
No, on their prayer.
You are challenging. Who is the plaintiff? They are the plaintiff.
They are the plaintiff.
Or the plaintiff themselves?
Yes, they applied for an. Initially, they applied for an ad interim order of injunction. They obtained a status quo on 10th of March 2016. I was kept out of the purview of 10th of March order because it fell from the learned judge hearing the applications. Thus, those defendants who have filed an affidavit in opposition or a demurrer to the suit, my lord, they will not be abided by the order of 10th of March 2016. Subsequently, they applied for addition of party, addition for my subsidiaries as well as for transferee. Now, transferee and subsidiaries both were added by the order of 9th of March 2017.
What is the ground of challenge primarily? What is the ground of challenge primarily?
It is the plain case that the defendant number 79 is a joint family company. If there are two brothers, then the brothers cannot be the, if at all they are the owners of the shares, the shareholders will not have any rights so far as the immovable asset of the company. And without being established that the defendant number 79 is a joint family company, its subsidiaries could not have been implemented. Because whether the defendant number 79 is at all a joint family property or company or not, that adjudication is yet to take place.
But for addition of party, the consideration will be the frame of the suit. I mean, you were saying the second point you were taking that unless that is adjudicated, they cannot be added.
Yes.
I mean, if they lose along with the subsidiaries, but it has to be decided on the frame of the suit.
Yes.
Addition of party.
But anyway, suit is between two brothers or between the brothers. At best, the brothers can be shareholders. or they can be a part of the board of directors.
Can you please show us the prayer portion of the release shot in the suit?
Yeah, the plaint is not annexed to this. I have a separate copy of the plaint as well.
Unless the plaint, we'll go through the plaint, we don't have a look at the conspectus of the whether they should be added or not. It depends on the frame of the suit entirely.
Yes, the plaint is not completely annexed, but I have a copy of the plaint. If
You completely annexed means the annexes are not there.
annexes are not there.
Let us see the relief at least.
Take a copy? Yes, I'll give one more copy.
আরেকটা copy দিচ্ছি। Oh, they say they are the joint owners of the businesses of the
Yes,
companies and all.
yes.
Owners of the companies and businesses. So they have to bring all the juristic persons also who are they come within the hotspot if they claim jointness of the. Your basic claim remains that shareholders cannot be the cannot have a right title in the assets of
the company.
That holds true for the suit also, main suit also.
Yes, and the application proceeds on the basis because one Katihar property was transferred.
Transferred by?
Transferred by my subsidiaries to the transferee.
Sir. That order 1 application is.
Yes, that is also there, Murad. The impugned application.
সঙ্গে কোনো স্টে অ্যাপ্লিকেশন বা কিছু নেই?
Yes, GA 156.
ওইটা পুরোটা ছেড়ে দাও। Yes, which should we look into? Which one?
The GA 156 of 2017 is the addition of party. That is at page 129.
129. First volume to the GA tar first volume to the.
No, state petitioner page 129.
120 first volume হবে। আচ্ছা ঠিক আছে। Repetition is it? কি?
পুরো নাম্বারটা আছে।
যে কোনটা দিলে?
হ্যাঁ, ওটাই।
এটা? Page
129.
129, yes.
129. Annexure B.
The cost title is killing us.
Yes.
72, second volume.
এটা পুরোটাই cost title পরে volume হবে। আচ্ছা দিয়েছো।
The second one.
Thank you.
172. 172. Yes, it starts at really 170.
কিন্তু এখানে ডেজিগনেশনটা আবার আলাদা হচ্ছে।
What is this? This is that application. এখানে তো cost title আছে না পুরোটা?
Oh yes, the body of the application starts at 173.
173. এখানে ভলিউম 2 এর নাম্বারটা তো আলাদা রয়েছে।
GA 156 starts at page 129. And since the cost title is enormous, the body of the petition starts from page 173.
But this volume 2 of this কোথায় পাচ্ছেন এটা? কোন ভলিউমে দেখুন?
16.
It is a volume 2 অন্য অ্যাপ্লিকেশন নাকি কোন অ্যাপ্লিকেশন? এটা ভলিউম 2 তে তো অন্য জিনিস রয়েছে। One of the judges copies volume 2, it's different.
I'll just check.
My learned brother's copy is all right, yes. The volume 2 contains 173. But this
cannot be volume 2.
I think the volumes have been got exchanged.
The cover page is incorrect.
Cover page is incorrect.
Because it's written volume 2, page 151 to 250. It cannot be from
2 and 3.
I think this should be volume 3. I think this should be volume 3.
Yes, and volume 3 is 2.
3 will be.
Cornish.
Volume 2 will be 3.
Yes, 173.
Yes.
ব্যাকশিটের নামটা দেখেছো?
So what was the ground? Main ground, where do we find that?
For that, if Lordship sees, Murad. Yes, Murad. It starts from, my lord, page 174, paragraph 5.
Yes. They also sought an amendment.
Yes.
That was allowed also.
No, the application has been allowed by the order impugned.
Application for amendment as well as addition of party. Two
Yes.
separate applications.
No, the entire GA 156 has been allowed.
156 sought for amendment as
Yes,
well as
as
addition.
well as, yes.
The only amendment sought was the cause title or the pleadings also to support that.
No, my lord, so far as this
Which is the addition of party.
is only the addition, because if Lordship sees the press,
Yes.
this application, my lord, does not contain any proposed amendments to be made in the
Oh,
plane.
this was the only application which was.
Yes.
Separately, the names are given and so many things. No, as indicated in red color on the copy of the plaint, annexed X.
Because the order impugned of 9th of March, my lord,
No, the prayer.
yes,
In prayer G, they seek for a leave
to amend
amend
the
the
plaint.
plaint in terms of red color on copy of
Yes.
plaint X. That is not there. That X.
No, that is not there. And if Lordship sees the order impugned, my lord, which is internal page 6 of the order,
So we'll come back on the next day
any day
because
after, my lord, 27th, if it's
we have a different bench actually. After 27th.
yes, sir.
Although the hearing barely started, comma, due to paucity of time, we cannot take up the matter further. Full stop. Accordingly, let the matter stand adjourned till September 3, 2025. Mr. Mitra, any difficulty? 3rd September, Wednesday week. So this is to avoid making it part-hard and at the same time to record the presence of the party.
But this barely word, my lord, creates
Barely is, it's not a part-hard.
It's create difficulties otherwise.
তুমি কি লিখেছো? হ্যাঁ, তারপরে তো সবটা বললাম।
এটা কোথা থেকে আমদানি হলো বলতে আমার
The manner, due to paucity of time, the hearing could দিন। First time appear করছো? Yes, anybody appearing for the parties? Jalpaiguri matter?
I am for the petitioner, Lordship.
What is the contempt?
Contempt, an order was passed on 30th July 2024.
Yes.
And that has not been complied by the CMOH. In judgment copy annexed herewith.
Yes, yes.
Para
Nothing
19 and 20.
Nothing has been done. No inquiry started.
Inquiry started and other conditions are not fulfilled till today.
You have been given a notice of hearing.
Hearing has been done. Whether it is concluded or not, that has not been replied to us. And thereafter, the inquiries has to be completed within 3 months. That has not been done, and apart from this, result has to be communicated nothing.
Right, right. Yes. Next copy. September 19th. We are keeping it on September 19th. We will direct you to serve copy.
As your lordship pleases.
A prima facie case of contempt has been made out inasmuch as it is alleged that, in contravention of the order dated July 30, 2024, passed in MAT 185 of 2023, the alleged contemners have not completed the inquiries as directed, nor has the outcome thereof been intimated to the present petitioners. Full stop. Accordingly, the petitioner shall serve a copy of the contempt application on the alleged contemner, indicating that the matter shall next be listed for hearing on September 19, 2025 at 1 p.m. September 19th, 1 p.m. Yes. Please give a copy. Acha, the petitioner shall file an affidavit of service on the returnable date. বাকি মেয়েটা তো দুটোর পর
My lord, may I be permitted to mention hearing of matrimonial appeal,
Yes.
my lord.
My lord, may I permit to mention item number 25 of today's list? This is assigned matter, my lord. This is very urgent because, my lord, the petitioner and the respondent number 5, both wives, are not getting family pension, my lord, since 2007, my lord.
Appearing in the list?
Yes, my lord.
Yes, my lord.
Which item?
25. Assigned matter.
Assignment.
I am for the respondent number 5.
I am for the petitioner.
72 years old lady. We are giving service without any remuneration. My lord, kindly, if your lordships accommodate.
Well, tomorrow this will be appear at the topic which আছে কাল? At the top of the hearing list.
My lord, I am grateful.
এই application ফিশনের পরে দিয়ে দেবেন কালকে।
I am grateful.
Thank you.
My lord, may I have lordship's kind leave to mention one application in connection with
Yes.
matrimonial application.
Yes.
But matter was due to appear on, supposed to appear on 19th.
Oh.
It was, the determination was that bench, my lord.
That's right. Very little appearing.
Because lordship may be permitted to mention one matter for inclusion. It was
appear on
supposed to
Monday.
appear, but it did not appear in the list.
Hand it over.
Grateful, lord.
But may it appear on Monday so that I can serve the other side notice.
সোমবার দিয়ে দেবেন তাহলে।
My great.
মানডে লিখে রাখুন।
Grateful.
Thank you.
My lord, in item number 1, my lord, I am for the petitioner, my lord. Last occasion, my lord, I could not
written notes.
Please, yes, I am ready with the written notes.
My lord, I am ready with the written notes and the 2 points relating to the irrigated and non-irrigated. My lord, I have given the chat. His case has been considered as the non-irrigated area and allowed the, my lord, the ceiling limit what has been held. And in respect of that order, that is neither the de novo proceeding nor continuation of the proceeding, but for implementation of the section 9 of the West Bengal Land Reforms and Tenancy Tribunal Act, that within 12 weeks, if any interim order before the High Court, that can be, my lord, extended, modified, or altered.
You have stated in your written notes all these things.
Two things, my lord, I have written these things, the main 2 things.
Whatever written will go into that. Yes.
My lord.
Yes.
My lord, last occasion, my lord, we were struggling to read the 2000 order. My lord, that was very illegible. Subsequently, my lord, I got hold of, and my lord, that was, yes, Mr. Mahata is right. That was invoking of section 9B of the West Bengal Land Reforms Tenancy Tribunal Act 1997. The subsequent dismissal by the tribunal has got no bearing in this matter, because in 2000 the authority invoked 9B of that LRTT Act, and my lord, passed this order and put it for further disposal. Well, kindly come to that page once. That is at page 50 of my writ petition. Proceeding started 1976. Thereafter, it stopped. Then again, 1985, it again started. Then after 1985, again it started in 2000. Well, July, 20th July 2000. My lord has got that. Page 50. Whereas on perusal of the case records of, if it appears that the proceeding was drawn up to determine the land to be allowed to retain under section 14T of the WBLR Act in favor of Subodh Kumar Pal, son of such and such. Whereas it appears that the Rayat moved the Honorable High Court challenging the such and such serial number of, well, that is the writ petition 1985. He is referring. By its order dated, stayed the proceedings with such and such not to proceed further. Then towards the এটা কি স্যার?
Disposal of the proceeding.
Disposal. Towards the disposal of the proceeding. Kindly mark that. And the
Instant proceeding.
instant proceedings has been lying pending interim order of date mentioned above, whereas then consequent upon the holding
The
of
decision, no decision.
the WBLR and TT Act 1997 and Constitution of Land Reforms Tenancy Tribunal, all matters relating to, there was a mandate of transferring the matters, and matters then stated act thereafter.
এই তো এখানে বলে দেওয়া আছে
Pending before the High Court, save and accept.
save and accept.
Then he mentioned about the 3 months,
12 weeks.
12 weeks
The provisionটা দিয়ে দাও
ঠিক আছে।
from the date of, I have quoted that provision in my written notes of argument. Section 6 of the Act 12/888.
আমরাও কোট করে দিয়েছি।
তারপরে next
hence the cases taken up for disposal issue notices upon the Rayat asking them to appear before the undersigned on 27 July 2000
at
such and such, and then to retain as per the provision of the Act.
in default, the matter will be
taken up ex parte. So in 14 একটু তুমি পরে বলো। Under chapter 2B vesting, the first one has to decide whether this is irrigated or non-irrigated. Then the composition of family on the date of vesting, that is 14th February 1971, in respect of chapter 2B, what was the family constitution and the member of the family. And then if he is happy with that, then the last course of action would be inviting the Rayat to file a retention form, which was under form 7A, subsequently after amendment 7AA. The Rayat is to come before the authority and exercise that retention. If Rayat does not come, if does not appear, then the authority's bounden duty is to give option on behalf of the Rayat. Then authority can give the option in lieu of the Rayat's option. Now, these 2000 proceedings had taken place against a dead person. That particular Rayat died in the month of June 1990. Hence, this entire 2000 proceedings is a nullity. This cannot be compartmentalized. The 14N has to be first decided, then family constitution has to be decided, thereafter the option has to be given.
no notice was served to us.
And no notice was served to us. And the subsequent dismissal, which I challenged in that writ petition, and 2005, which got dismissed before the LRTT, that dismissal also against a dead person, that had happened in the year 2005. So both the orders are, in my humble submission, are nullity, non-est.
If that be the position, তাহলে proceeding is void ab initio.
What was done by the impugned order? Just remind us.
The tribunal has not considered any of the
You
submissions.
take this point, nullity point.
Yes, I have taken this point. I have a ground. I have pleaded in my way my lord, I can show from the paragraphs which are the paragraphs.
How was it dealt with by the tribunal?
No whisper. Tribunal has said, since you have asked for swapping, that you wanted to give the option from instead of X land, you want to retain Y land, X can be vested, X land can be vested. That means you cannot travel beyond that. My lord, I say, my lord, estoppel does not lie against the provision of law.
Both the order passed in the name of dead person.
Both the orders were passed, my lord, against the dead person.
Tribunal by the authority.
Now, my lord, kindly come to, my lord, para
এই যে বলা আছে এটা আমার লেখা আছে
para 28
এই
of my writ petition.
না অরিজিনাল
Para 28.
No, my lord, page 28, para Roman 6.
Yes.
My lord has got it.
Yes.
That your applicant states that recently they came to learn that 5.42 acres of land has been vested in the name of Rayat, late Shubodh Kumar Pal, and though directed him to give option, but option was not given because Rayat, late Shubodh Kumar Pal, moved a writ petition against illegal vesting order and obtained an interim order of injunction till the disposal of the rule by the Honorable Justice such and such as the then was, and that thereafter 1997 the West Bengal Land Reforms Tenancy Tribunal Act came into force. The matter was transferred before the Honorable Tribunal. Be it mentioned here that the petitioner late Shubodh Kumar Pal died in the year 17 June 1990. Then, my lord, next paragraph, Roman 7, that your applicants further states that submit that when on 20th July 2000, the RO directed to issue notice upon Rayat by fixing date on 27th July 2000, no notice served upon them or received upon if any notice issued is against dead man, as original Rayat Shubodh Kumar Pal died long back in the year 17 June 1990. My lord, as also, my lord, kindly come to the grounds mentioned in page 31, ground number 3.
এটা রিলিফ এটা হ্যাঁ গ্রাউন্ড ঠিক আছে
Grounds for relief, my lord, at page 31, my
dead
lord,
person, in the name of a dead person.
then Roman 4 and, my lord, Roman 6.
এটা এটা দাও নো নোটিস
Yes.
So entire, my lord, the subsequent proceedings had taken place behind our back.
You put that in a written note.
Yes.
Yes. What is your answer to that, Mr. Math?
My lord, if your lordship kindly might see my written notes of argument,
Yes.
my lord, it will be everything clear. My lord, Steve, my lord, first two paragraphs, the description, then the on 7th August, he held 26.27 acres of land. And my lord, I have given the chart in irrigated, non-irrigated, how much he is entitled to. My lord, if your lordship can 7 members, he is entitled to in non-irrigated area 20.76.
But he was dead at the point of time. How could you pass?
My lord,
He was dead at the point of time.
it is 85 order. Vesting order completed in 85. Stay. High Court stay. Then, my lord, if your lordship kindly see, my lord, the tribunal said.
For a vesting order, no?
No, nothing, no vesting order, nothing. If your lordship kindly see. দুটো বই দিয়ে দাও
Land Reforms Act কোথায় থাকবে দেখুন তো act
Land Reforms and Tenancy Tribunal, my lord, another copy is there, my lord.
তো উপরে ছিল এই তো উপরে থাকবে দ্বিতীয়টা দেখুন তো
My lord, another copy, my lord. Here, I have quoted the provisions.
এই তো এটা চলে গেল
কি দেখাতে চাইছো তুমি? 9
9
উপরে ছিল
6 months
9
Yes.
AB proviso.
Yes. ওটাতে নেই ওদেরটাই দেখছি হ্যাঁ হ্যাঁ আছে আছে লাস্ট ইয়ার
Section 9
ইয়েস
AB proviso, provided that
Yes.
any interim order granted in a matter exceeding the proceeding or a case by the High Court shall stand vacated on the expiry or 12 weeks from the date of appointed by the state government under Section 6 of, unless the tribunal by an order varies, modifies or extends the same earlier on an examination of the records and such matter of the proceeding. Now, the 15th July, my lord, I have stated that, my lord, in my written notes of argument, the 15th July is only that portion. Within 12 weeks, he was given notice that whether the after my lord, the proceeding, my lord, was concluded. Thereafter, my lord, that whether there is any interim order has been extended by the tribunal within 12 weeks or not, I have given the dates, my lord, that my lord, if your lordship kindly come, my lord, page 3 of my written notes of argument.
Yes.
Granted interim of 7th or 9th, which has been extended by the learned tribunal within 11/11/1998, that is the appointed date of the tribunal, and within 12 weeks, the interim order ought to have been extended. As it was not extended on 27th July, my lord, the notice has been issued to appear before on 27th July.
So you say it was a continuation of the same proceeding?
No. Continuation of the same proceeding. 85 proceeding. 85th July. Whether interim order has been extended or not.
It was not extended, therefore did vacate.
Therefore, my lord, the authority are liberty to proceed in accordance with law. That is, my lord, and I have clearly stated in my written notes of argument, the order dated 25th July is neither the reopening of the final vesting order dated 3rd September.
Could you proceed like that in the name of a dead person? That is what is pointed.
My lord, a dead person, my lord, it is that, my lord, that in 85 vesting order has been passed. He has been allowed the ceiling limit. What my learned friend is that irrigated, non-irrigated inquiry does not apply in this instant case. He has been allowed holding total land is non-irrigated area. So the question of inquiry, the decisions or relating to that.
When was that held?
My lord?
When was that held? Non-irrigated area?
My lord, on September 1985, during the lifetime of the riot.
Where do we get that order?
My lord, my lord, the vesting order is under challenge. My lord, page 43 to my lord.
This one, this order itself.
My lord, itself.
Right.
And he has been allowed, my lord, 20.75 acres. My lord, actually, my lord, the law says, my lord, I have given the chart. It ought to have been 20.76. 1 decimal is, my lord, discrepancy is there. But agricultural and 1 decimal, if my learned friend said that he is entitled to 1 decimal, we can give. I have given the chart, my lord.
All right.
And relating to the, my lord, I have relied upon a decision of the Supreme Court that what is not averred relating to that claiming of that 85 proceeding is not challenged in the 2014 LITT proceeding. The vesting order, there is no averment in the vesting order. Here it is the case is that 2020's order is bad in law in view of the dead person. Not challenge of the 85 order, the vesting order which has been concluded in 85 and during the lifetime of the riot, that is not under challenge.
After his lifetime, what happened? After his lifetime, what happened?
After his lifetime, my lord, 85 therefore interim order. We cannot proceed with for distribution of the land. And my lord, if your lordship kindly come, my lord, I have given the judgment annexing it.
Yes.
Only one paragraph, paragraph 13.
Sure.
As has been already noticed, although the point as to profiteering by the state was pleaded in the writ petition, but before the High Court, as an abstract point of law, there was no reference to any material in support, therefore, nor was the point was argued at the hearing of the writ petitions. Before us also no particulars, no facts have been given in the special leave petitions or in the writ petitions or in any affidavit, but the point has been sought to be substantiated at the time of hearing by referring certain facts stated in the application of HFIDC.
This point was not regarding irrigated or non-irrigated.
Irrigated, non-irrigated. Here it is non-irrigated, and if he is aggrieved anything that he has to make an application to the authority. If the authority fails, then there is appeal. Here does not arise. And the ceiling limit, in respect of that, he has been given ceiling limit. If he is aggrieved by that, he have to take specific point. I am entitled to another ceiling limit that is to be given to me, that was not given, and that is why the order is bad in law. That is also not pleaded.
Shall close arguments on this?
My lord, yes.
Learned counsel for the parties file the written notes of arguments as per previous direction. Push up. Hearing is concluded and the matter is reserved for judgment.
My lord, my senior sir, my lord, asking me to, my lord, show, my lord, just only one paragraph, which is at page 45.
45.
My lord, kindly come, my lord. Mr. Mahata just right now said that we have never taken this point, that this is a irrigated or non-irrigated. Kindly come to page 45 and kindly read the only first paragraph.
There can be only one first paragraph.
Of Arambagh PS, which include the plots owned by the Rayat are within
Irrigated.
Non-irrigated.
notified.
No, that is his point. Mr. Pata's point is this was decided in 85.
85, and we have held him, allowed him entire non-irrigated area. I have given the chart.
That is his point.
Vesting completes when 14 SS and 14 BB is taken up. That means possession. From the notice till the taking over of the possession, vesting does not gets complete.
Illegality or the
Once
impropriety
the
of
possession is taken up, once the possession is taken up, then vesting gets completed. Not in the meantime. It cannot be compared.
14 SS and
segregated.
14 SS and
14 SS read with 14 BB. That is the rule. How to take the possession? Then it
My lord,
ends.
my lord,
Then vesting gets ended.
yes, my lord, that would be done because of pendency of the petition and
it
other
was
things.
stayed and all then.
Stayed and other things, my lord. We have vested 5.42 acres of land. The vesting is complete, but we have not taken possession. We have not distributed it. 14 acres pendency. Vesting has been completed.
Next matter. Pathidavan.
Deeply obliged.
Deeply obliged, my lord.
সবাই তো develop.
Affidavit.
Yes, sir.
Yes.
দুটো আছে তো?
Have you given a copy to them, Mr. Banerjee?
দিয়েছিস? না না কপি পাইনি। এ দিবি তো। Sorry, my lord, I should have forwarded this. Order. My lord, first paragraph indicates, my lord, my residential address and, my lord, my place of work. Then, my lord, paragraphs 2 and 3 are, my lord, my undertakings. And, my lord, page 4 is, my lord, my native address.
You have given a residential address, you say you work elsewhere.
Yes, my lord, I have said so, my lord, in first page. By occupation, residing at, etc., and working for gain
Yes,
at.
yes.
Both, my lord, I have given. My lord, I have also annexed my, my lord, driving license over there, page 5. my lord, in proof of that. Page 4 is, my lord, my native address. My lord, this is it is Aadhaar card issued by, my lord, Government of India.
Yes, Mr. Chokot.
Yes, my lord, that satisfies my lord.
Yes, sufficient. So, and you were saying something.
Regarding the appeal, my lord, the appeal, my lord, is ready for hearing. My lord, paperwork has already been filed. My lord, kindly fix the date. My lord, any day, my lord's convenience. My lord,
We'll keep it on September, we said.
my lord, Mr. Chatterjee probably suggested after the vacation. So if my lord may fix after the vacation also, my lord,
November month. Yes. This application we are keeping pending.
Yes,
Personal appearance is dismissed with, obviously. We have dismissed with already. Until further we have dismissed. So this application will appear along with the appeal now. The affidavit of undertaking filed as per previous direction by the alleged contender today be kept on record. Full stop. In view of the filing of such undertaking, comma, the alleged contender is permitted to leave the country, subject to honoring the undertaking. Full stop. Next para. Since the appeal is otherwise ready for hearing, it is ready for hearing.
the paperwork has been filed. It has been filed. It has been filed. I have filed it.
Since it is submitted by learned counsel for the appellant that the appeal is otherwise ready for hearing, let the appeal along with the application, let the appeal be listed for hearing in the monthly list of November 2025 along with the contempt application.
A date, my lord, any date.
No question of date. Affidavit of undertaking filed today be kept on record.
Liberty to mention.
Then we'll withdraw that direction.
No.
What are you saying?
Grateful to you.
Yes.
Lord, I did happen to petition on my letter.
Mr. Kush, this is out of a matrimonial proceeding. So you are the husband. Yours should dismiss or theirs should dismiss?
I should dismiss.
So you are sending the matter to mediation. Mr. Arup Kumar Datta was appearing for the sole respondent. Can you give a notice to him?
Right.
Give a notice and we'll take up tomorrow and we'll send. This is for mediation purpose. These have been earmarked. The matter has been earmarked for sending to mediation, since it arises out of a matrimonial dispute. First of the learned advocate for the appellant is requested to give a notice to his counterpart appearing for the respondent, indicating that the matter shall be listed tomorrow under the same heading. First of the learned advocate for the appellant shall file a receipt in that regard tomorrow. Thank you. Just give them a notice. We'll send it for mediation. Let us see. Thank you, Mr. Ghosh. Yes.
I am for the appellant.
Yes.
On the last occasion, there was a direction upon us to serve the to intimate the
Affidavit of service.
My lord, that could not be prepared. The affidavit of service has been prepared, but on the last occasion, I was the advocate appearing on this.
No, service has been effected.
Yes, my lord. The service has been done. My lord, affidavit could not be prepared.
On the morning, you could not affirm the affidavit.
No, my lord, the advocate appearing in this matter, there is a death of his
In the
family
family.
member, and he is in his native place till now.
So you can.
The affirmation could not be done, my lord. The
Advocate did not affirm.
Yes, my lord. The advocate is not here.
Advocate's clerk affirms the affidavit.
My lord, the sign.
Some other yes.
Sign.
So when should you keep it?
My lord.
Service has been effected.
Yes, my lord. Sir.
When will he come back?
Next week, my lord.
Learned counsel appearing for the appellant submits that the learned advocate on record for the appellant had to leave town, and as such, the affidavit of service could not be affirmed. Full stop. Accordingly, let the matter stand over till August 25, 2025, when it will be listed under the same heading. Please get it affirmed in the meantime, and on 25th August it will appear. And we will send it for mediation most probably. Just indicate to your client. Give your name only, not yes. Yes.
My lord, item number 5.
You are for the appellant.
My lord. Pursuant to the direction, my lord, we have served the intimation to the respondent wife.
Service effected.
My lord, After receiving the notice, my lord, the respondent contacted my advocate on record and sent a WhatsApp message regarding the
Let us
service of my lord.
Longish message. What is there? What is the content?
My lord, she has received first paragraph. She received a notice on 16th of August, my lord. Thereafter, on the last second paragraph, she wanted to appear by virtually or to time to appear before my lord, my lord. Yesterday, we have sent a link to appear virtually, my lord, but
You have sent a link.
no, yes, my advocate on record.
How could you?
By
On behalf of the other side?
no,
You are for the respondent.
I am for the appellant.
Appellant, yes.
She contacted my advocate on record.
Oh, so you arranged for the link to be sent to her.
Yes.
Fair enough, but she's not appearing. Learned counsel for the appellant files an affidavit of service in court as well as the printout of a WhatsApp message. With a printout, comma, which indicates that the respondent had sent a message to the learned advocate on record for the appellant seeking to make necessary arrangement for her to appear virtually. Push up next para. It is submitted that such arrangement has been made by sending a link, sending a virtual link to the respondent. Push up, however, comma, at the time of call, the respondent is not represented, comma, neither does she appear personally. Push up next para. In any event, comma, since we are not proposing to pass any order affecting the merits of the matter or the rights of the parties, comma, further notice is deemed unnecessary. Full stop, since the matter arises out of a matrimonial dispute, comma, in our opinion, the same should be given a chance of being settled by mediation. Full stop, accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of facilitating mediation between the parties.
I'm grateful.
Thank you.
Lord, I appear for the
Yep,
petition.
that apparent.
Lord, I have.
They have received?
Yes, they have received. They have received.
Despite service, none, it arises from matrimonial proceeding.
Matrimonial proceeding, my lord.
Despite service, none appears for the respondent. The affidavit of service filed to be kept on record. Full stop. Since the appeal arises out of a matrimonial dispute, comma, we deem it fit to send the matter for an attempt to reconcile the dispute between the parties by way of mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of exploring the option of mediation between the parties. Thank you.
I am appealing behalf of the petitioner, my lord. I am praying for not today.
No, not today. This is only for mediation.
But on record, Mr. Shoil Kumar Maiti.
Maybe.
Not a mediation case, a land matter.
What? Then we have to give you time.
Remembered.
What is the matter about?
I don't know, my lord.
My lord, mischief has been committed by my officer.
What has?
Since 2019, he has kept 140 new proceeding pending.
They've asked for early disposal of that.
No, tribunal again has given a time to this gentleman. Now this gentleman knew he has assumed chair in July 2024. He has sent a mercy petition to be placed before your lordship. He wants 3 more months, my lord, to complete the proceeding. If I may place this. Nothing more, lordship, can mean. I don't have any defense in this matter.
The dispute is what? That you have not complied with an order of the court.
That yes, no, there was a direction earlier. You complete the proceeding under section 14U.
Yes, that you have not done.
So many successes are passed by, did not. So, my lord, may I just place this last paragraph of this instruction he has sent to my lordship?
Where is the impugned order? Let us see that.
Impugned order is last annexure. Last annexure of your lordship's brief, lordship. Since 19, this has been going on. Miss case.
So what is the ground of challenge?
Ground of challenge, why this time limit has not been given. Simply here, learned tribunal said after extending opportunity, suitability, convenience, and authority vested with him. Why not time frame given? Kindly see.
Ask. Let us see one of their grounds because they are not present. Just will.
Lordship.
Page 11 onwards.
Page 11 onwards, Lordship.
Thank you.
Non-application of mind.
Yes.
First.
Yes. 3 months you have asked for.
He has, my lord. I have got it written from him. Page 3, last paragraph. Now, I don't want to stand in, my lordship. Only enough, my lord, sufferance. 2015 started, only renumbered as 2019, nothing else. And that has been demonstrated by my learned friend in the writ petition also. Kindly sees the notice, page 83 onwards. Page 83 onwards are the notices, lordship. And this gentleman officer has assumed chair in July 2024. That also 1 year has passed by. Lordships haul him if he does not complete within 3 years. Kindly 3 months.
If you give him 3 years, we will be hauled up.
No, Lordship, 3 months. Sorry, my lord. 3 months, keep him.
An adjournment is sought on behalf of the petitioner. Full stop. Next para. However, comma, since the prayer in the writ petition is innocuous and the state is represented by learned senior government advocate, comma, we refuse such prayer for adjournment. So next para. The learned senior government advocate hands over a written instruction. Full stop. In terms of the same, comma, the current incumbent in the post of the block land and land reforms officer, comma, Mohishadol, comma, Purbo Medinipur, has expressed
it is my humble submission, he says.
Has submitted before this court that 3 months time be given to conclude miscellaneous case number 06 of 2015, which was later renumbered as Miss /6 LAW Pro Bloque /19. Full stop. Next para. The grievance of the writ petitioner is that although the said proceeding is pending for almost 10 years, comma, the same has not yet been decided by the tribunal, by the BLNLRO. Full stop. The learned tribunal, comma, by the impugned order dated May 15, 2025, merely disposed of the challenge of the writ petitioner in that regard by directing the BLNLRO to dispose of the proceeding, comma, without fixing any time frame. Full stop. Next para. It is unfortunate that the writ petitioner has been running to pillar to post for so long. Full stop. However, comma, we are made aware that the present incumbent in the post of BLNLRO has joined only last year and was not aware of the pendency of the matter as such. Full stop. Keeping such submission and the fairness of the BLNLRO in mind, comma, we dispose of WPLRT 120 of 2025 by directing his respondent number?
Respondent,
revenue officer.
Respondent
block,
2,
yes, 2.
2, lordship.
By directing the respondent number 2, comma, the block land and land reforms officer Mohishadol to dispose of miscellaneous case number 6, to dispose of Miss/6, Miss MISC /6 LAW block /19 arising out of OA 34 of 2012 as expeditiously as possible, comma, positively within 3 months from this date. Full stop. The BLNLRO, the concerned BLNLRO shall act on the communication of the learned advocates coupled with a server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance. No arrest to cost. He'll do it within 3 months. Tell your learned advocate on record.
May this be written with the record.
The written instructions filed today be kept on record. If they don't, then this time file a contempt application.
Certainly, Lordship.
Thank you, Mr.
Lordship.
And thank you for the fairness.
No,
Yes.
Lordship. Yes,
Both of you.
Lordship.
Yes.
How can this a citizen?
8. Yeah, yes.
The short issue will be.
It was short till Mr. Agarwal was appearing. Obviously, it's a long issue because you were appearing.
My machine is always short, my lord, your lordship. No.
No, Mr. Shortkar is also short, but he has to justify his presence.
Whether an essential tender condition can be waived either by the authority or by the court. The vacancy notice said that the land in question must be commercial, vastu, etc. But
This is in connection with what? For a petrol pump or something?
No, this is for
Rationing
FPS
dealership. MR dealership. or something.
FPS dealership nowadays is called
FPS.
fair price shop.
Fair price, all right. Yes.
Well,
Yes, Mr. Shortkar.
they will file the affidavit reply, madam.
Affidavit reply. Opposition a filer? Right. Yes. Yes, please continue, Mr. Shortkar. So, what were the yardsticks again, please? One is the yardsticks, Bastu.
Yardstick that the land must be commercial or vastu, etc.
Yes, what was not complied?
The land and as the date of application of the private respondent
Yes.
was Bash Bagan. The authority said this should be condoned. The court said this should be condoned.
Bansbagan is commercially viable in West Bengal.
Very subtle, well, very nice, excellent.
So it should be given a go. It's not a Vastu, definitely. Bansbagan, if someone chooses
Neither
Bansbagan as a
commercial,
Vastu.
neither commercial.
Commercial bamboo can be sold actually.
No, it should be recorded as a commercial. Of course, bamboo can be sold. This is one of the principal
So
grounds.
subsequently you cancelled them at dealership or not given to him at all?
It was given to private respondent by ignoring, by
Refusing his. No.
Contrary to the vacancy notice.
Unsuccessful candidate is challenging the selection.
And that was allowed.
No, that was refused by the single judge.
The court said
Successful
is the
one had the
confirmation,
bamboo.
nothing wrong in
But the successful person. Oh, acha. Very well.
May
Let us see. Should we
very
start with the?
quickly glance through the some papers, some facts, ma'am.
Yes.
Now, page 46 is the vacancy notice, which is the principal document in this litigation. We both are relying upon that. Page 46, annexes C.
Yes.
Lordship. Lordship, can you see clause 1 small a at page 46?
Yes.
Application invited from A, an individual permanently residing in the Ranaghat subdivision. One of the complaint was the private respondent was not residing permanent resident of Ranaghat subdivision, but his name appear in the voter list. We have annexed document in Krishnanagar subdivision. This is one of the reasons. Now, next. Logically turns over the page at page 47, about page 4, middle of the page for Panchayat area.
Yes.
It must have the space of minimum 300 square feet, along with a covered space of 100 square feet adjacent to the godown to be used for office purpose, for weighing and e-post operation, total number of compartments for shop and godown should not exceed 3 and should be adjacent, connected to each other. However, if the godown and shop are accommodated in a single compartment, area should be minimum 400 square feet. These are the eligibility criteria. C is C. Minimum height of the godown should be 2.43 meter, 8 feet along with side walls. The plinth level should be 0.60 meter, that is 2 feet.
This was a panchayat area.
This was panchayat area, Lordship.
So none of these were fulfilled. If it was a bamboo grove, then how could it?
Lordship. I'll come to that. 60 from the road level, down level. Then the applicant applying Roman 5, applying against a vacancy of repair shop must have a ready godown as per the above norms on the date of inspection. However, if the godown is otherwise ready, following deviations, exceptions at the time of inspection may be ignored. If the structure of floor, wall, and roof of the proposed godown is complete, floor is otherwise ready, but the tile cement finishing is not done.
This must have been done at the date of the inspection. That is the relevant date, Mr.
Shok. That's not the issue. Now, so these are the things. Now, part 3. Following persons, entities shall not be eligible to apply for a license of APS dealership. I. A person holding a license of APS dealer or distributor holds in his name, or a person whose relative, as per clause 2XA of the WPDS MNC order 13 already has a APS dealer or distributor or wholesaler license. This is also one of the grounds for the incapacity of private respondent. I'll come to that. Then part 4 at page 48.
The relative was a APS dealer.
Yeah, Lordship.
Yes.
Part 4.
Part 4.
But subsequently he obtained a divorce.
To get this APS dealership.
Anyway, part 4. Roman 7. Documents related with godown and shop come office. Lordship got it? The middle of the page. Page 48.
Part 4.
Part 4, middle of the
Roman,
page.
yes.
Roman 7.
Got it, yes.
Documents regarding possessional right over the proposed place of business. A. In case of ownership, shared ownership, photocopy of record of rights, registered deed of conveyance, purchase deed, applicants, beaten. Next, this is very document showing character of land as dokan, commercial, bastu, if record of right is not produced. So the character of land must be dokan, commercial, bastu.
They produced record of rights.
They produced, it showed Mash Bagan. And there is the report. It's a little checkered history. Now, NOC of other co-owners in the form of affidavit in case of property owned by a family member of the applicant. So, this is the eligibility criteria. Now, my lord, I made an application at page 50. Is my application form. At page 52, I gave the godown size and other things. At page 52,
was by lottery or what?
No, selection by there are several criteria on their marks. On their marks, highest marks will get it right there. Clause 44, character of land of premises, commercial, homestead, non-agricultural, mine is commercial. And at next page, page 53, if share whether other co-owners have given NOC, proposed place of business in the name of applicant's husband name, Bachu Das, NOC to his wife, Gori Das, for APS business purpose. So, NOC was given in my case. Now, Lordship come, page 54. This is my sanction plan. Lordship, can we see? 23rd January 2019. This is my sanction plan. Now, page 55, Lordship, can we see? This is, I have made a complaint, it was annexed to that. 29/9/2024, Bagachara Gram Panchayat is writing that এত দ্বারা সংশ্লিষ্ট সকলকে জানানো যাইতেছে যে শ্রী মৃন্ময় পাত্র, there is a private respondent here, নামীয় ব্যক্তির রানাঘাট মহকুমায় অন্তর্গত কোনো বাসস্থান নাই, এমনকি তিনি মিথ্যা তথ্য প্রদান করে ব্যক্তিগত প্রভাব খাটাইয়া রানাঘাট মহকুমার ভোটার আইডেন্টি কার্ড সংগ্রহ করিয়াছেন। উপরোক্ত শ্রী মৃন্ময় পাত্র অঞ্চল পঞ্চায়েত প্রদত্ত কোন রকম কোনো অনুমতিপত্র হোল্ডিং নম্বর ছাড়াই 2024 সালের জুন মাসে
What is the locus standi of a panchayat member?
any
Must be a ally or some other consideration. Panchayat member, Gram Panchayat member does not have any locus standi to issue.
voting, possibly trying to help the appellant, possibly.
Obviously, yes.
জুন মাসে অন্য কত জমিতে গুদামঘর বানাইছে যাহা বাস্তু জমি নহে, so whatever worth, my lord. Then, my lord, this is the page 56, record of rights,
certificate of conversion.
This is a conversion certificate given, they are dated on the right hand top, Lordship, can you see, 4th October 24.
So Masbagan has been converted, conversion has been permitted to Bari.
Afterwards, but it has to be as on the date of application.
Why do you say that as on the date of application? From which portion of that?
Lordship.
You could place the tender document. From where do we get it?
These are the documents which should be annexed along with the application form. So at page 48, item number B, document showing character of land as Dokan commercial Bastu. If record right is not produced, it has to be filed along with the application. And he got, that's why what I'm saying, that this is the closing date was sometime in May. He applied sometime in May. 14th April I have applied. And this is 14th October 2024 is a conversion certificate, and his application is 30th September 24. So till when he applied.
When did he apply?
He applied sometime in May. This there.
May 24.
No. Applied for this APS dealership. That should be in sometime April or May 2024, man.
22nd April 2020.
22nd April 2024.
22nd April.
Second April 24.
All right.
So this is, it was Bansh Bagan, and now it has been classified as Bari. Certificate of 4th October. He has applied even on application dated 30th September 24. So as on 22nd April 24, it was still a Bansh Bagan. And his application could not have been considered even because it did not have the eligibility criteria.
Is it your case that he did not furnish a photocopy of the record of right?
He must have furnished, but the authority said that is Bansh Bagan as on the date, we are condoning it.
B, Mr. Shark, is conditional on records of rights not being produced.
Lordship.
You may say that this can be read into that record of right requirement, that it cannot be on a different footing.
And there's an admitted facts, 22nd April application.
But it may very well be, Mr. Sharkar, that suppose one produces records of rights. It's seen that it's not a Dokan commercial or Vastu.
Then it should be rejected.
No, that is not there because A does not specify that registered or this is not a criterion.
Yes,
because the criteria in the
they are the
previous page-
documents. These are the eligibility criteria for applying.
No, this is only conditional upon records of rights. Not suppose one produces a records of rights which shows it's something else, Bansh Bagan or whatever else. But then there is a credibility issue also. So the authority knows what it is. Provided he converts that and gets a go down build there before the date of inspection, it could be permitted.
Inspection is also over. And
Token commercial Vastu.
The law on the subject is also there. this
If
is there.
if the purchase is not produced, then something has to be produced.
Yes.
Either Dukan or commercial, or it all already has to be a Vastu.
My lord,
When was the inspection held? Must have been before that he has cured.
I'm giving the dates. My lord, I have a list of
Yes.
dates. Inspection date. Inspection. My lord, may I give a list of dates?
What is this?
29th
List
of
of
May
dates.
2024, Miller. First inquiry, physical inquiry.
June 1st.
29th of May.
29th of May.
Private respondents was of 3rd of June. Petitioners was on 29th of May.
Petition is a writ petition.
The appellant as well. Appellant writ petitioner is the same person.
Oh, yes. Their inspection was held in on
29th of May.
But the other side's
3rd June.
And the respondents.
4 days after 3rd June.
The allegation is against the respondents. So, very good.
My lord, apropos this, my lord, may I, the control order provides, this is a statutory form which provides, a copy also.
See, even on the date of the inspection, it was not converted.
No, admittedly. And this is the, I will say, statutory form. So this is the law on the subject.
Don't have another copy.
I don't have another copy, my lord.
But this we have to rely on then. What is this?
This is the control order.
No, you had on the last occasion you handed over certain bunches. Different.
It's 2024, it's 2013. That is statutory form.
No, the ones which you handed over are not applicable.
So that is applicable in that case, man.
This vacancy was prior to 1st August 2024, so it will be governed by
2013. This control order will apply.
We need just a photocopy of this.
Of course, well, I will make a copy and give.
Front page and this page.
Of course, my lord.
Other character.
আপনি এই বইটা দিতে এই বইটা এটাতে নেই স্যার আপনি কি দিলেন স্যার
1.48
স্যার কি দিবেন সেটা দেখতে
1.48 দেন 1.46 থেকে স্টার্ট হচ্ছে 1.48
on or before the date of application.
Plus yes. So it's very clear that they did not have. Okay.
Photocopies of this?
Yes.
Thank
you. Front page টা না দিলে
আপনি কোনটা
ওইটাই দিচ্ছি এখন 13 এর না এটা আচ্ছা কপি দিয়ে দিচ্ছি
Later on, please give us the front page of this, the control order.
So, my lord,
This is the form same
let us say admittedly,
yes,
as on the date of application or on the date of inspection,
yes,
this land was not within the parameters prescribed in the vacancy notification. So he did not have the eligibility criteria as on the date of application. Now, lordship, in the above background, my lord.
What about the Ranaghat issue? How was that?
Ranaghat issue, it is subsequent.
What was their defense?
I'll come to that because this went up pursuant to order of court to the authority. Authority passed an order, so relying upon that will be much easier for me.
No, but what was they produced something else to show they reside in Ranaghat?
My lord, page 60, my lord.
What did they produce?
I'll immediately show
the rival panchayat members certificate. Or?
No, not that. There are more interesting things, my lord. More interesting things, my lord. So, page 60. This is my. I made a complaint. Basically, Roshi is fine.
Yes.
That his name is a voter list of Krishnagor. Second paragraph.
Yes.
13 purchased land in March, constructed according without conversion of land and also without sanction plan. There was no sanction plan annexed. And then mandatory condition from Gram Pradhan certificate issue. This is one complaint. Then page 62, the second complaint, I say that when the inspection for my go down, they came for inspection. My client was made to sign on blank papers. So that he wrote to the secretary by complaint 20th August at the last paragraph. The inquiring officer obtained signature on blank pre-printed sheet, and I put it there on
This is which page? Which page?
Page 62, bottom, last paragraph.
Acha, yes. All right.
And I made the that to favor a particular applicant who is a blue-eyed candidate of the SCFS. The subdivisional controller, his blue-eyed man, I made a specific allegations and also said I have made to sign on blank paper.
At this point of time, they had come to Mr. Agarwal. That's why blue-eyed and all this fancy language. Please.
That's it. Possibly, my lord. Then, my lord, I annexed with this the voter list and all
So,
these things.
what happened to you? You are rejected. Why? Because of that blank paper.
Immediately. Page 68, my lord. Then I came up before this honorable court.
Right.
This honorable court passed an order at page 68, directing the secretary to consider. At
Very
page
good.
68, under the above sample, the representation is
Consider which
disposed of.
one? Both representations against them and your blank
Consider the representation of the petitioner and shall pass a reasoned order of hearing the parties. He'll consider my representation because they have not made any representation.
No, you made two representations, one against them and other regarding
No,
your
both
blank.
against them and one against SCFS. So that SCFS one was directed to be considered after hearing both sides, the private respondent also, and shall pass a reasoned order and so on. Then page 70 is the order passed by the secretary. This is very important, my lord, because his subsequent order is contrary to his own order. It's very interesting. This 21st November 2024.
Yes.
These are all the background facts, not necessary.
Team was formed. Inquiry team was formed.
Then, my lord, at page 73. These are my submissions recorded.
Inquiry team was formed.
Then, before that, by page 74, logical missings.
Yes.
What are the charges? And lordship say, why I am rejected? What are the charges? Page 74 is recorded. So, because I have no opportunity to know why I am rejected. I get in the website is found rejected, but why rejected is the first time coming in this order. So this order is irrelevant. The SCFS, subdivisional controller, Ranaghat, against whom allegations were made, has further submitted there are some grounds on the basis of which the petitioner's case, that is the appellant's here, was not recommended. One, minimum required plinth height is 2 feet, but the petitioner's go down plinth height is 1 feet. One is plinth. Two, minimum size of the go down space is 300 square meter, but petitioner go down measure of 260 square feet. Three, no shade was there in the petitioner's go down. At the time inquiry as per report of inspector, the go down was incomplete. There are the 4 allegations against me. Why I was rejected. Now, considering the above facts, lordship, this is a finding and circumstances after hearing the matter in compliance with the solemn order and judgment of the Honorable High Court dated 27th February 24, the undersigned is of opinion that a team from the headquarters is to be formed for inquiry into the matter. So he was somewhat convinced that there may be something wrong. So he said, no, it will go back to subdivisional controller. Or
there is a prima facie opinion expressed in deference to the order of the High Court. Let me form a...
But normally inquiry is made by the district authorities, but here he is forming a team from the headquarters, from Calcutta.
Because the High Court directed, that's it.
No, High Court didn't direct Calcutta. High Court said will consider.
High Court directed him to look into it.
To look into it.
The district court had directed, then he would have taken the district officers.
Anyway.
So this is not a formation of anyway. What happened after that? Let us proceed.
The deputy director is directed to cause an inquiry and remeasure the size of go down. Also, logically see what to do. In this case, the inquiry in the grievances raised by the petitioner in this case remeasure the size of the go down of the petition also of the recommended candidate, and to submit a report with undersigned within 10 days. So when logical page 75, logically takes the three allegations or charges against me. Plinth 1 feet, logical see measurement of go down, logical side the plinth height, logic got it. There are
Plinth
two go
height
down.
measurement and shade. No
Last
shade.
column, plinth height.
Yes.
They say it is 1 feet. He found is 2 foot 2 inches, 2 feet 2 inches. Office room is also 2 foot 2 inches. There are two go downs, one office feet. So the first inquiry report was wrong. He found it 2 feet 2 inches plinth 1. Next, minimum size of go down is 300. The petitioner good measure is 260 square feet. Lordship got it. Now, Lordship can see total area of go down 258.4 plus 113.22 square feet is 371.62 square feet. So, second charges also found to be wrong. Now the third, no shade was there. Their shade is mentioned 26 feet by 13 feet 8 inches. Shade, the last row. So all the charges against me were found to be false or incorrect. There are the three charges.
Yes.
Always now Lordship can't
Go down was incomplete. What about that?
I mean,
Fourth charge.
If it is already plinth area, measurement, everything is there, it is complete. So no question of incomplete. Other you would have measured it at all.
And you have stated that there was no cement plaster, for that only it has been held.
Where?
At page 74, you have stated that there was no cement plaster, only on one side wall. So that for that it was held to be that cannot be a ground for holding incomplete.
Now the impugn order logically the date is very important because it is like Ramayana. It was even Ram was born
before. Yes.
Ramayana was written 30th January 2025 is the date.
Which page?
At page 77. So after this report came, then he was supposed to find a final reason report. So 30th January he files a final order at page 77. And logically mark the date. The private respondent was given allotment or appointment on 22nd January 2020. Logical mark the date that I have stated. 22nd January 2025. That is stated at there's of course there's a admitted situation.
Yes.
22nd Lordship at paragraph 9 of my state petition, paragraph 9, subparagraph S.
All right.
It is my statement on 22nd January 2025. The subdivisional controller issued offer letter appointing the private respondent as a dealer against the vacancy in question. And the final order was passed on 30th January and communicated, Lordship can see, copy forwarded for information, subdivisional controller on, this is on 30th January 2025. So, the offer letter 22nd January is itself a suspicious document. Could not have been issued by law. Everything is eyewash. Now, Lordship kindly sees that at page 78, the final order.
But the inspection had been held. There was no stay on the offer letter being given or something like that. That process was continuing.
No, I am not on that. But my question is, a final reason order is to be passed. After that, they can do whatever they like. I can challenge it also. So they
can
can
challenge it, yes, but
so
they proceeded with their work.
no,
That would be subject to whatever order, subsequent order comes.
even before 30th January order is passed.
Order is not passed. They are given an offer letter.
That
In
is
terms of the previous inspection already held
not
because they have
previous
been.
inspection. No. Without this final order, they couldn't have issued that offer letter.
This was the inspections of both of you were held. Process was going.
And court
culmination
directed
of the
the secretary to consider.
of your representation.
So the whole proceeding was
You were
statement
already rejected
condition.
and the proceeding was going on, and in culmination of that, they were given an offer letter.
It cannot be because before the final order is passed. Because at
Not
page
necessarily.
74, Lordship kindly sees
Court does not pass
last
any
line.
You
Page
are angry
74.
with your rejection, you come up with a representation that was directed to be
Lordship
considered.
74 Lordship comes to last sentence at page 74 of the first order by the secretary.
Yes.
After receiving the said report from the inquiring officer, the final order will be passed upon considering the entry.
Final order on their representation, on your representation.
On representation, considering the dealership. So it can be put, cart can be put before the horse.
All right.
So, Lordship, I'll first come to the respondent part at page 78. There are two parts. My disqualification and his disqualification, private respondent, both are disqualification, but how it is condoned. Considering the vacancy notice, the following page 78,
we are there.
About bottom of the page. Considering the vacancy notification enclosure 24, following disparities noted against Minmoy Patro. That is the private respondent. First, the classification of land at the time of submission of application for FPS vacancy on 22nd April 2024 was Marshbagan. Admitted fact, recorded. And it appears that no application for conversion was submitted before the date of submission of application for FPS vacancy, contrary to memo number 36792 of 11/9/2024. Admitted situation, I have shown that for that statutory form that it was not submitted. Conversion, no application for conversion was submitted even. Now, the Minmoy Patro has got the land converted on 4th October 24. That I have shown that document. Right, memo dated so and so. It is also reflected for able record the name included in the voter list of Ranagarh subdivision earlier than submission of the application of APS dealership. So the allegation in this respect is not tenable. They say that the name was also there in Ranagarh subdivision. That is the finding, whatever may be. Now, therefore, on the basis of inquiry report and on the basis of observation made therein by the Deputy Director, DDP&S, Food and Supplies Department, the undersigned is of the view that disparity of the recommended candidate, that is private respondent, is much more lesser than that of instant petitioner. But the question of higher or lesser.
Let us see your disparities. You have not placed that.
I'll place that because this is more glaring. On account of the above mentioned ground, the disparity appears in the application Minmoy Patro regarding conversion of land matter may be condoned in comparison disparities found in Gauridas Bishas. In fact, both should have been disqualified if both are disparity. Lordship. As the disparity found in Minmoy Patro is much lesser. So it is expressly contrary to the vacancy notification. Now, Lordship can see, possession of land is not established. This was not there in the alleged charges at page 74, only 3 charges. The ROR is the name of Bachuda's husband of Gauridas Biswas. The vacancy notification said that a NOC has to be given if it's the name of family member, and in my application I have shown I have given NOC. So this is wholly redundant. At the time of submission application against FPS vacancy, no rent tenancy agreement was uploaded in the portal. Not necessary. It said NOC only. And unregistered rent was uploaded by concerned inspector. Additional document in the portal. notarized rent agreement was provided on Atto, executive Bachudas, Godbisha, 19, executive and so and so. Malad, these are subsequently asked for given, but they are not at all necessary. What was necessary was NOC and have given at the time of application in according to the vacancy. So, and in any event, this was not in the charge placed before the secretary on the last occasion. At page 74, I have shown only 3 charges. Plinth area, size of the godown, no shed. And the order travels the charges, my lord. If I put it my legal, if I formulate my points, the impugned order, final order, travels beyond the charges. Next 2, the layout map uploaded in the portal of Goridas Vishwas, there is appellant here, and by the inspector is different from the one submitted to remeasurement or 11/12/24. 10, which such that modification done in the layout plan. It appears from layout plan and physical observation in the site in the first inspection has been shown as go down during inspection on 11/12/24, and the portion shown as shed is in layout plan during first inspection. And inspection are different. My case is the first inspection I also signed a blank sheet. The secretary appoints a inquiry committee. Inquiry committee gives a report that the 3 charges against me are wrong, and he gives the correct measurement. Now the secretary now is deciding, after the second report came, it overrided the first report. Now he's deciding difference between the first report and the second report. This is wholly arbitrary, my lord. My respectful submissions are, this is wholly arbitrary, because I came with a plan. The first report I was made to sign blank papers. Court, the secretary, as directed by court, the secretary appoints a new committee. New committee gives a report. Now he says there is discrepancy between the first report and second report, so I am rejecting you. He should have ignored the first report, only considered the second report, because the first report got overridden by the second report.
The number 3 against you is more serious. That the physical observation suggests modification in construction of the goods.
No, when the
because
uploaded
Mr.
GPS
Sarkar,
tag
one
pictures-
cannot ascertain by a subsequent inspection what was the position when they first inspected.
True, my lord. But the charges were not these.
No.
Charges were only 3.
This first charge is entirely new.
Second is also new. There is a
Yes.
difference between the first and the second. This is also new. There is no charge like this. Third is also based on the first inspection and second inspection. GPS tag pictures dated 20/5/24. These were never submitted to me.
No,
Where from
layout
they come?
plan, you submitted a different layout plan at the time of remeasurement, that is being said.
No, from the uploaded GPS tag pictures dated 30.
No, number two, layout plan, layout map uploaded in the portal by you and inspected is different from the one submitted during remeasurement.
Remeasurement.
That suggests that a modification has been made to the layout plan, including the plinth, obviously.
Where are the allegations against me? This is the inspector. This is by the inspector, and the inspector is different. This is a layout map by the inspector.
On the rejection, they are not required to give a reasoned order.
No. But here, my lord, when they have given a reason,
High
they
Court
have
directed,
to
High Court directed, Mr. Sarkar, only your allegation that you were made to sign on a blank paper, that is to be looked into. Now, therefore, they were not required to say all these things also.
Lordship. And in any event, my lord, Lordship says that the GPS tag pictures, these pictures were not given to us. I don't know what was there. So an order on the basis of undisclosed document, my lord, is violative of the principles of natural justice. But these are the three grounds on
You are
which
given a hearing otherwise.
I was given a hearing. I made my submissions. At the time of submissions, my lord, none of these points were raised. Otherwise, I would have answered them. They said it's incomplete. I've answered yes. One wall is
minor.
negligible factor. None of these were raised. These are behind my. I mean, after the hearing is over, they come out with new issues. So, my lord, may I formulate my points now? My legal points.
Yes.
Firstly, very interesting thing. Lordship, see. Lordship, can you take the affidavit in opposition once? Page 74. Page? If the opposition by the private respondent.
Yes.
By the state, I'm sorry. By the state at page 74. When there's a marking system, my lord, if I'm disqualified in one point, I will not get marks in that point. I'll get marks in other points. Lordship, look at the mark sheet. I mean, it's an atrocious mark sheet, if I may use. Page 74, item number 3, Minmoy Patru.
Yes.
19, 21, 20, average 20. And Lordship sees, those are absent, Lordship skip it. All others are 0. In a marking system, it can be 2, somebody 5, somebody 10. He's 20, but others cannot be 0. It's a totally preconceived. Marking system, I mean, forget me. There are other 2, 3 persons. How they can be 0 in a marking system? Lordship can see the next part. Evaluation of applicants. 3. Recommended all the documents are submitted and fulfill all the criteria. The land document itself was defective. Everything is preconceived, my lord. It was a post-decisional hearing. And next, Gorilla Bishop not fulfill all the criteria. Whereas I fulfill all the criteria, the private respondent did not. And all 0. Here also marks, evaluation of marks, all 0. I could understand he got 22, I got 5, somebody got 10, somebody got 20, but all 0. It's a preconceived thing, my lord. Now, I was trying to formulate my points. Yes. I'm sorry, I being normally a note, but
this shocked your conscience.
So, firstly,
yes,
relaxation of the terms of vacancy notice was illegal. Or if Lordship allows me, I will make just formulate my points and the cases, come back tomorrow or day after.
We complete your argument today. We'll hear both of you. We'll ask you to do that tomorrow or day after. Yes. This is first one.
Relaxation of terms of vacancy notice.
Placed all the papers.
Yes.
So just put that on a yes.
Lordship, I'll put it. On this, I submit 2 cases. Now, second is the first report stood overruled by the second inquiry report. I was declared ineligible on the basis of first report. This is arbitrary and unreasonable. In the first hearing, there were 3 charges against me. But the final order, I am not rejected on the basis of those charges, because by second inquiry report, those charges were found to be incorrect. I was disqualified on basis of totally new points. In other words, the order travels the charge. On this, I'll cite a decision. Now, they say GPS photo as on 29th May. No copy was given to me. It is neither stated that copy submitted. In fact, none of the points I was allowed to make any submission. Whole thing was a post-decisional hearing. K.I. Schaeffer's case, man. So order based on undisclosed material is also natural justice, violative of natural justice, man. Next. And the order was communicated on 30th January 2025. The offer letter was January 22, 2025. In other words, this order is nothing but a preconceived and a post-decisional hearing, and is an eyewash. And one more date, my rejection is on 25th January 25. 4 dates. Order communicated by the secretary to the subdivisional controller 30th January. Offer letter to the private respondent 22nd January. My rejection is 25th of January 2025. Before the final order, I was not rejected by anybody.
When was the High Court order passed? Justice Samanta's order?
The order was passed.
Directing you to consider this. Pardon?
11th. Oh, sorry.
8th October 2024. First order.
First order.
Yes. The one which directed you to.
8th of October.
8th October 24. No. 20. Oh, court's order. I'm sorry. Court's order.
He's generally very thorough. I've never heard him say a wrong thing in court. He may lose or he may win.
My lord, this is a
I've never
very good habit which will pay him in the long run, my lord. Very good habit, my lord.
Yes, Mr. Shokar.
Now, and one more thing, my lord, that
so all this rejection, their acceptance was done after that order of High Court. So you say that that order was there. They were to complete the report, but before doing that, they gave these things, rejected you.
So everything is a post-decisional hearing.
Preconceived and post-decisional.
Very. And one more thing, that I have shown that form C, that note, that is statutory form, providing when this conversion is to be made, that part. So, and now the impugned orders. I'm sorry. Impugned order starts at page 80, and the findings are at page 91. 90. Again to first. Page 91 bottom. And before that, I'm sorry, the decision-making process, I'm sorry.
Yes. Yes.
The decision-making process of the principal secretary appears to be justified, and which is in pursuance of the provisions of the control order. Well, I have a question mark there, because I have shown the statutory form. He said this be condoned. He had no power to condone. Next, the petitioner has challenged the decision of the principal secretary in respect of the relaxation in favor of private respondent. The relaxation I have challenged. It appears to me the principal secretary is the highest authority to decide the issue who would be the fit candidate for issuance of license. I mean, there's no dispute, but he has to decide within the four corners of the vacancy notice and and the statutory form as per the control order. The decision of the competent authority regarding choosing a person to be fit for running a license is the sole prerogative of the competent authority who are the expert in that field. My lord, with utmost respect, my lord, in that event, no order passed by a senior authority could be challenged in court. It further appears to me that it is a mandate of the statute that proposed short-term go down should not be run over a land which is not dokan, commercial or bastu. For that reason, it has been provided that prior to the issuance of license, the classification of land should not land where the go down was constructed should be changed to dokan, commercial or bastu. In that event, the private respondent has made an application conversion of the land on 30th September 2024, much after the date of application. And the conversion was done on 4th October 24, that is prior to issuance of the license. In that score, I think it is justified to hold the decision for relaxation of the condition. It appears to me not irrelevant, illegal, or biased. So, that for relaxation, my contention is, my lord, with utmost respect, that nobody could give any relaxation of the tender conditions. And if the conditions relaxed, that should be relaxed for all the people. Secondly, this condition of the tender condition coupled with the control order condition makes it a mandatory provision. And be it principal secretary or chief secretary, nobody can relax a mandatory clause of a tender condition. I find no materials in the allegation that offer letter was issued in favor of the private respondent and prior to the impugned order. Well, the records are all there. It's nothing more. It is admitted fact that issued on 22nd January. The state admits that, and so may I go to the cases? প্রথমে আমাকে দিন 2017 আমার ট্যাবটা 2017 বিশ্বাস দুটো কপি দেবেন 27 হ্যাঁ দিয়ে দেবেন হ্যাঁ দুটো আছে দেখেন একটু 2020 বলে দিচ্ছি volume 17 Supreme Court cases, page 577. Only paragraph 16 I am relying upon. There are the certain case laws discussed. I am not on that. Straight away at page 586, paragraph 16. Yes. It is clear even on a reading of this judgment that the words used in the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. Given the fact that in the present case, an essential tender condition which had to be strictly complied with was not so complied with, the appellant would have no power to condone lack of such strict compliance. Any such condonation as has been done in the present case, would amount to perversity in the understanding or appreciation of the terms of the tender conditions, which must be interfered with by a constitutional court. Well, this is my first submission. The next decision I want to cite is 2023 SEC Online, Supreme Court 1408. My lord, in this decision, I rely upon paragraph 21 and 22. 23, I'm sorry. Paragraph 21.
Yes.
In Bedango Talukdar versus Saifullah Khan, this court highlighted the fact that any power of relaxation of the stipulated selection procedure ought to be mentioned in the advertisement in the following words. We have considered the entire matter in detail. In our opinion, it is too well settled to need any further reiteration that all appointments to public office have to be made in conformity with Article 14 of the Constitution of India. In other words, there must be no arbitrariness resulting from any undue favor being shown to any candidate. Therefore, the selection process has to be conducted strictly in accordance with the stipulated selection procedure. Consequently, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There cannot be any relaxation in the terms and conditions of the advertisement unless such a power is specifically reserved. Here, my lord, no power is reserved for relaxation of the land classification. Such a power could be reserved in the relevant statutory rules. Even if power of relaxation is provided in the rules, it must still be mentioned in the advertisement. Nothing was mentioned advertisement. In the absence of such power in the rules, it could still be provided in the advertisement. However, the power of relaxation, if exercised, has to be given due publicity. Two conditions are not fulfilled. There is no power of relaxation in the advertisement. There is a power of relaxation in the control order. And it was not given any publicity that this can be relaxed. Then possibly some others also could have been equally placed, could have been applied.
Yes.
This is necessary to ensure that those candidates who become eligible due to the relaxation are afforded equal opportunity to apply and compete. Relaxation of any condition in advertisement without due publication would be contrary to the mandate of equality contained in Article 14 and 16 of the Constitution of India.
Yes.
Now, on this is a well known proposition. The order cannot travel beyond the charges, but Lordship allows me to place one decision on that. 2006 4. And Mr. Agarwal is 15 days older to me.
Nobody would say that.
4 SCC, age?
2006 4 SCC 713.
Yes.
I'll be relying upon paragraph 26 and 28. Page 724, paragraph 26. In our opinion, the learned single judge and consequently division bench of the High Court did not pose unto themselves the correct question. The matter can be viewed from two angles. Despite limited jurisdiction of civil court, it is entitled to interfere in a case where the report of the inquiry officer is based on no evidence. In a suit filed by a delinquent employee in a civil court, as also a court, in the event the findings arrived at in the departmental proceedings are questioned before it, you should keep in mind the following: the conditions for a departmental hearing. The inquiry officer is not permitted to collect any material from outside sources during the conduct of inquiry. Now, Chief Secretary was considering my representation. In that, the GPS tagged photographs of May 2024 by the first inspection, which according to me was a binding paper. He could not have relied upon that too without giving me a copy. So the inquiry officer is not permitted to collect any material from outside sources during the conduct of the inquiry. 2. In a domestic inquiry, fairness in the procedure is a part of the principle of natural justice. 3. Exercise of discretionary power involves two elements, one objective and two subjective. And existence of the exercise of an objective element is a condition precedent for exercise of subjective element. 4. It is not possible to lay down rigid rules of the principles of natural justice which depend on the facts and circumstances of each case, but the concept of fair play in action is the basis. Next, my lord. 5. The inquiry officer is not permitted to travel beyond the charges and any punishment imposed on the basis of finding which is not subject matter of the charge is wholly illegal. So, my lord, the final order is illegal in my case as it travels beyond the charges mentioned page 74 of the earlier order. 5. Suspicion or presumption cannot take the place of proof even in domestic inquiry. The writ court is entered to interfere the findings of the fact of the tribunal or authority in certain circumstances and so on. Then paragraph 28. Yet taken in share Bahadur's this court observed. It may be observed that the expression sufficiency of evidence postulates existence of some evidence which links the charged officer with the misconduct alleged against him. Evidence, however voluminous it may be, which is neither relevant in a broad sense nor established in a nexus between the alleged misconduct and the charged officer, is no evidence in law. In my case, those tagged GPS tagged photographs, or that there was difference in plan. So, evidence, however voluminous may be, which is neither relevant in a broad sense nor establishes any nexus between the alleged misconduct. My alleged misconduct is three charges: plinth, area, shed. And the charged officer is no evidence in law. So, those three grounds on which I am rejected, they are no grounds in law. They are illegal and they are no evidence at all. Now, Mala, the next decision that the order based on undisclosed materials. Lordship 1993, Volume 1, SCC 13. Didi bhai. Citation paragraph 4 and 5. Paragraph 4 and 5. Paragraph 4 and 5 I am relying. Lordship, you already seen it. No point wasting time.
Exactly on what you are saying, that materials should be provided.
Otherwise, it becomes bad.
Obviously, yes. Although
As
these are
I
in
said,
respect of
they are well-known propositions.
these are in respect of departmental proceedings, but even then general
nonetheless,
principles
for
of
administrative
audio alternate partem broadly comes in.
Lordship. Then the next case 1994-5 ও বাবা, সাজানো আছে আরেকবার আপনাকে দিন ভাই
দিন
1994
খেয়াল রাখবেন
volume 5 SCC
yes
page 118 paragraph 3 and 4. This reiteration, my lord, I the same is a well-known proposition.
Yes,
I need not read out.
Need not multiply judgments on the same proposition. This is set.
And also that when here the vacancy notification read with the control order is the law for this purpose. When a law prescribes a thing in a particular manner, that has to be done in that manner or not at all. So neither and for 89 এর একটা কেস আছে দেখুন 89 হ্যাঁ oh sorry. And on post decisional hearing, K.I. Shepherd Lordship is well aware, my lord, and it was followed subsequently also in 89 1 SCC 764. 89 1 ও আমার কাছে লেখা নেই 89 1 আছে আর একটা কপি দিন না 89 1 হ্যাঁ 87 actually this is followed there because এটা দেব দরকার 89 টা দাও 87 is not necessary 89 1 SCC 764 প্যারাটা বলুন তো
12 and 13 from the head note
12 and 13 K.I. Shepherd is followed here. So I'm not separately citing K.I. Shepherd. So this was a post-decisional hearing and it's a bad.
Post decisional hearing in the sense that everything was done, their offer was given, yours was rejected, and
then the order came. Lordship, give me a minute, half a minute. Question of law. My little point may be taken that these are not argued before the trial court. My lord, point of law can be taken any time. I don't have to cite any decision on that before your lordship, my lord. I definitely, even if my junior
all of these points were argued in the
some relaxation was argued, of course. Some points may not have been argued.
Others are not pure questions of law because mixed questions. Definitely, all these are true that post decisional hearing documents to be furnished, but you have to argue that those are not furnished. All these things.
My lord, this was argued. My lord, I'm told. This was argued. My lord, Mr. Agarwal was there. He says it was argued. No documents supplied. Yes.
Marking system.
My lord, one document, my lord. One gazette notification, not document. No.
Document is
gazette notification. How marking is to be done on land.
They're entirely new points. This was not before the learned single.
I mean, all I want to say, it cannot be zero.
Yes, zero you have to argue.
That's it. Oh, state wants to rely upon that. Then I can. Then I can. Oh, Lordship, can you permit us another 5 minutes tomorrow or day after, any day?
You don't have it now?
Huh? I don't have it now.
So we'll see from the state, you will reply you once. Yes. In any event, we'll give you time to file your short written notes, as you said. And in reply, you can deal with that. Yes. Yes.
The issues regarding go down, were the primary issues. Other issues were dealt, and not much emphasis has been laid down on those issues, like issues of residential certificate and issues of family member holding a license. My lord, it was just mentioned, it was not argued, but we'll address all those issues. My lord, we have filed our affidavit in opposition. My lord, kindly, if your lordships can take. It is to state. Subdivision. But your lordships have already gone through the vacancy notice.
Yes. But you can place the relevant portions if you want.
On the relevant portions of vacancy notice, my lord, which I want to rely upon, is at page number 47 of the appeal, my lord, stay application. My lord, the clauses which were placed by my learned senior.
Permanently residing at Ranaghat, you say that no, he also had.
At the time of issuance of vacancy and at the time of inspection, private respondent was on the voter roll of Ranaghat constituency.
Yes.
And my lord, it is also mentioned in that Panchayat member's letter which was placed. Although he mentions that he included his name by practicing some fraud or by some dubious method. But nonetheless, my lord, we are not the authorities. ECI is not party here. So my lord, he was on the roll, admittedly, of Ranaghat subdivision, and his residential part was established. We also conducted further inquiry with that to that effect. My lord.
You say that the date, relevant date is not the date of the application, but the date of the inspection.
My lord, it is mentioned in the vacancy notice only.
Where is that?
Lord, kindly see the next clause is mentioned, was placed before lordship, clause number 4 on the same page. Kindly see after the table, clause number clause B, 5B.
5B, yes.
But everything has to be seen on the date
5B,
of the
page 46.
Page 47, my lord.
47. Yes, 5B. Yes, on process.
Kindly see clause 5 first. Applicant applying against a vacancy of fair price shop must have a ready go down as per the above norms on the date of the inspection. However, if the go down is otherwise ready, following deviations and exceptions at the time of inspection may be ignored. My lord, the deviations and exceptions are laid down in subclause A.
Yes.
Deviations and exceptions are if and only if the structure of floor, wall and roof of the proposed go down is complete and the floor is otherwise ready, but tiles and cement finishing is not done. So, my lord, plaster of wall is not a deviation which is to be ignored. The wall was unplastered. I will place the photographs, the GPS tagged photographs which were being mentioned, my lord.
The wall, if the structure of floor, roof and wall is complete, in their case it was complete, floor is otherwise
not,
ready.
my lord.
It was not.
But one of the walls was not
done.
Only, my lord, the flooring, the tiling of the floor.
Structure, it says structure of the wall is to be complete. But finishing, cement finishing is not done. That is plastering.
Cement finishing, my lord, of
But
tiles and cement finishing, my lord. But even the one of the wall was not complete till the roof level.
No, let us read the entire thing. A, if the structure of floor, wall and roof, their allegation is on the floor, on the wall.
Wall and floor, both.
Floor also, and if the structure of the floor, wall and roof of the proposed go down is complete, the structure was complete, floor was otherwise ready, but tiles, cement finishing is not done. Plastering is cement finishing. The structure was there.
Plastering, my lord.
What else is plastering?
One of the walls here was not finished up to the roof level.
Oh, not constructed. Not the structure.
One of the walls was not finished, my lord.
Oh, finished in the sense not finishing.
Not till roof.
Achha.
The wall was there, but there was some gap.
Partial. Achha.
And the workers are there. They are working at the time of inspection. The workers are working in the go down. We have disclosed images, my lord.
Yes.
So, my lord, this is the particular clause which led to their ineligibility.
Achha.
If they are ineligible, being unsuccessful, they cannot challenge any further things, my lord, because unsuccessful candidates do not have any right to disturb the selection process. My lord, apropos this clause in the vacancy notice,
And thereafter, one more clause, which is the principal contention of the petition appellants, is clause 10(7) in part 4 of the vacancy notice, that is at page number 48, my lord. Your lordship rightly observed that clause 10 subclause 7 B, that is document showing character of land as Dokan commercial Bastu, if record of right is not produced, it is contingent upon non-production of record of right or deed of conveyance or purchase or gift.
There's one thing here. Now, can they, the standard has to be the same, because otherwise it would be meaningless. Comparing apples with oranges, as they say. I mean, if you say that if they don't produce records of rights, they have to show documents of Dogan commercial Bastu, then that is the scope of inquiry in records of rights also.
Record of rights, along with record of rights, there are two more documents. That is the
yes.
deed of conveyance, purchase and gift.
So you put that on a similar footing as minus those, at least this.
Generally, in a registered deed of conveyance, the character of the land is generally mentioned. That was the case in this case as well, my lord. The deed is not annexed. I will place the deed, my lord, if so required. So, my lord, since the registered deed was uploaded along with the application, and it had some bearing with regard to character of land, actual use of the land which was being used.
What had they uploaded? Only registered deed of conveyance.
My lord, I will place the inquiry report. They have uploaded the registered deed of conveyance of the proposed go down. Lord, these are the two clauses in the vacancy notice which I wanted
one other
to place
thing,
it as.
page 47.
My lord.
No.
Lord, kindly see clause C as well.
C of?
5C at page 47.
Yes, C.
However, if any of the wall or floor or ceiling or roof is incomplete on the date of the inspection, the go down will be treated as incomplete, and the application will not be further processed. It will be marked as incomplete go down in the portal, and size and pictures as on the date of the inspection will be uploaded. However, no marks will be allotted against such applicant. This submission was made that others will get 0. Others are getting 0, and only the favored child is getting some marks.
Blue-eyed boy.
Blue-eyed boy, my lord. That is negated by this clause. That is why, my lord, the circular which my learned senior wanted to place, and your lordship said that it was not part of the record. I want to place that circular, my lord, because that circular has to be seen in light of this this clause. There is a reason for giving 0.
All right.
Because, my lord, an incomplete application will not be processed. They will be called for inquiry. They will be given chance to justify whether it was complete or incomplete. But, my lord, they will not be awarded any mark if it was actually ultimately found that it was indeed incomplete at the date of the inspection.
It's specifically mentioned here. No marks will.
My lord.
All right.
Thereafter, my lord, kindly takes my affidavit in opposition.
One second.
My lord, before the single judge, before honorable single.
Half a second. Yes.
Your lordship is at stay application, my lord. May I place the impugn order once, my lord?
Yes.
Before the honorable single judge, this matter was decided on the very first day. We did not got any chance to use affidavit. But, my lord, before commencing our arguments, we had handed over all the inquiry reports, which has been relied upon by honorable single judge to frame his opinion on the list. Not kindly take that that has not been placed before your lordship. Not kindly takes page number 86 of the impugned order, which forms part of the impugned order. That is internal page number 7.
Yes.
Lord, at the very, Mr. Bandopadhyay was appearing, Lord, he is also engaged in this matter. I am appearing.
Last.
Mr. Shishannu Bandopadhyay, Lord, was engaged in this matter. Lord, he is also engaged before this court. Lord, I am equipped with instruction, Lord, so I am placing the argument.
No, you are confident enough.
Lord, Mr. Bandopadhyay, before commencing his argument, he placed a copy of the inquiry report of the petitioner as well as the private respondents after supplying a copy of the same to the petitioners. The copy of the inspection report forms part of the Honorable Single Judge's record. Lord, those copies had not been disclosed in the stay application, so we had disclosed those copies along with our affidavits.
Yes.
Lord, may I place my affidavit in opposition?
Yes.
The documents annexed there. Lord, the first document which we have annexed is the inquiry report of the petitioner. The first inquiry report of the petitioner, on the date of which his godown was incomplete.
Yes.
Lord, Your Lordship, at page number 29, Your Lordship will get that inquiry report. Lord, kindly see the date of inquiry is 29th of May 2024, as I submitted. Lord, the second column, name and designation of the inquiry officer.
Yes, yes.
Date of inquiry is 29th May. And date of publication of the vacancy notification was 1st of September 2023. That is, Milord, column number 3 in the second table.
Yes.
So, Milord, law which existed as on 1st of September 2023 will be taken into account. Accordingly, Milord, the 2013 control order is applicable in this case. Milord, the petitioner filed his application on 14th of April 2024, and thereafter, Milord, kindly takes clause number 54 of this inquiry notice. That is at page number 34 of the affidavit in opposition. Clause number 54, sir.
Yes.
Clause 54, the column is whether the shop come go down and has a veranda with shade to accommodate at least 5 people who may wait in the queue. And the tick mark is on no, option no.
No, these were not part of the eligibility criteria.
This one, Milord.
In the vacancy notice, this was there.
In vacancy notice, Milord. May I place that?
Oh.
This also forms part of the vacancy eligibility criteria.
Show us that.
Milord. Milord, kindly see the table for Panchayat area. There is a table.
Yes.
In table, Milord, I'll place the entire table. The godown should be of minimum 300 square feet. Page 47, Milord. The specific condition is condition number E. The veranda with shade to accommodate at least 5 people who may wait in the queue is desirable.
So these are only reflected in that inquiry report columns.
Milord, all these clauses, whether they have been fulfilled or not, this is reflected. Milord, kindly takes the entire table because the plinth height factor is also there.
Yes.
The first criteria, Milord, is the size of the godown, which should be minimum 300 square feet, and the covered space of 100 square feet, which will be used for office area to process the ration shops and hand out the ration cards. Thereafter, Milord, there is another condition that the godown should be well ventilated with the roof, concrete slabs, asbestos, having bituminous coating and cemented tiles and floors. Minimum height of the godown is to be 8 feet, and the plinth height of the godown is to be 2 feet from the road level.
Yes.
Lastly, Milord, there is a veranda or shade which is desirable. So, apropos this, Milord, kindly takes condition number, clause number 54 of.
In their case, it was no.
It was not constructed on 29th of May. A second inquiry report has been produced, placed before your Lordship. There is only one page of the inquiry report which has been annexed. In that, the inquiry was conducted on 11th of December. After more than 7 months. And filing of one writ petition. I will place that as well, Milord. The entire report. So, Milord, we were at clause number 54. That is at page number 34 of my opposition. The shed was not constructed. Then, Milord, kindly takes clause number 57. Status of construction of floor
if complete or incomplete. It shows incomplete. And then the reason for incompletion, ready but cement tiles covering not done, not ready at all. So it says cement tile covering is not done. Then Miller status of construction of wall. So Miller floor was otherwise there, cement tile covering was not there. Then the tick mark is at clause number D. One or more walls are not complete up to roof level. So Miller, the structure part is not complete up to roof level.
61 and so many others.
Milord.
Delivery truck can reach the ground.
Then Milord, clause 61 is the plinth height.
No. 60 is the plinth.
Status of construction of roof. It is concrete slab. So it is there, Milord. There is a concrete roof. Whether it's complete or not complete, it is not there. Since there was a roof, but the wall was not up to the roof. Constructed up to the roof. One of the walls
held up by the other three walls.
There are three walls. There are bamboo structures for holding the roof. I'll place that images.
Okay.
Then Milord, kindly clause number 61, whether delivery trucks can reach the godown for loading or unloading. There is no. And 60, plinth height, minimum plinth height was 2 feet. At that time, it was 1 feet. Then Milord, there is a comment on suitability. It is declared as semi-suitable, last, clause 69. And the reason for declaring it as semi-suitable is written. Plinth level not fulfill, PDS controller 2013. Spot verification executed by us that tile stretch and gap of tile approved go down is designed by the authenticated civil engineer if not tallied.
Anyway. If
At
not,
least
with MR go down. As per control order.
Mine part
Not middle of service.
Mine was
Several
if
things.
with
Not middle of service area, no shade in front of
no shade in front of the accommodation, at
5.
least 5% at the time of inspection size of the go down is
electricity, floor not cemented.
Milord.
Anyway.
Electricity is not there, Milord. It can be condoned. So
yes.
I'm not. So Milord, the reason for declaring it as semi-suitable was given by the. Therefore, Milord kindly takes the next clause, clause number 70. At the time of inspection, it was disclosed that it's a leased place. Now it is being submitted that husband gave no objection in favor of wife, and in favor of that an notarized lease deed was submitted. That is clause number 74. Even notarized lease deeds are accepted.
Clause number 70.
70 says it's a leased or rental possession. Yes, but not as per control order.
What does the control order say?
Look, control order says registered deed.
Not registered. That's.
It was notarized lease deed, but Milord, in other cases it is
That's
also
not
accepted.
Not a fatal.
It is also accepted, Milord. To be fair, Milord, it is also accepted.
Yes.
There is an amendment.
Nowadays, it is also accepted.
And that was not there in that your.
It is not a ground for the rejection.
Not for rejection.
Now, kindly see clause 74. They have submitted an unregistered lease deed. Then overall comments are there. He is not recommended because of the reasons mentioned therein. Proposed shopcom go down, not middle of the service area, no shade in front of the go down to accommodate at least 5 people. Or at the time of inspection, size of the go down is less than that of the order of PDS 2011. Level plinth level not fulfilled under as per PDS control order, electricity not available, floor not cemented, sketch map is wrong. In form C, lease deed not submitted as per control order. Distance from the landmark to go down is 400 meters. Structure of shopcom go down is like a house. The proposed shopcom go down is situated at the link road, Dhalai Rasta, width 8 feet approx.
And they were rejected when?
This is the first physical inspection. After this physical inspection, this inspection report is compiled by the subdivisional controller.
3rd of June. 3rd of June, their application was rejected.
On 29th of May, this inquiry physical inspection.
Rejection was when?
in the next year on 22nd of January 2025. This is just the first process. After this, SCFS compiles this data and he puts this data on the portal. Automatic marking is done as per the memo which was being submitted. After this automatic marking, it is marked. They are marked out of 75. So whatever mark they receive, it is given, and this mark is sent to a district level fair price shop selection committee, which consists of an representative of district magistrate, who is usually additional district magistrate general, district controller of food and supply of that particular district, and the concerned subdivisional controller of food and supply, who is the license issuing authority. These three persons then conduct interview, and based on that interview, they award 25 more marks. Those marks were the marks awarded by the district level fair price shop selection committee was the marks which was placed to your lordship before your lordships.
Yes.
Out of 25, 3 persons gave certain marks. So then the entire recommendation was sent to the department, and then rejection or acceptance happens, which happened in January next year. But this was the first inquiry report of the petitioner. Thereafter, at page number 38 is the page which is allegedly the petitioner signed on a blank paper. This is the layout of the map on the date of the inquiry.
On the date of inquiry, this was the only paper they signed.
They say that they signed this blank paper.
No, this is the only paper they, even if it is not a blank paper, this is the only signature of theirs.
There is also another performer. It is not annexed, Milord, here.
Proforma could not have been a blank paper, but this could have been. I mean,
there is a drawing and everything, Milord.
Yes.
And Milord, at page number 39, I don't know, Milord, whether it's colored or black and white photographs are there. Mr. Lordship kindly sees, it is not visible from this.
The black and white will do, no difficulty.
Milord, the walls are not plastered, and one of the wall is not.
Which one is the short wall?
Milord, in black and white image, it is not possible. Milord, I have colored images. If your lordship can produce it from this, Milord. Page number 40. Milord, they have bamboo structures. Construction is going on, and Milord, everything is GPS tagged. Kindly see the date. Date is 29th of May 2024. The date is appearing, and the GPS coordinates are also appearing. So I am not inspecting somebody else's go down and showing it in their name.
Yes. But we don't know the latitude and longitude.
Look, latitude and longitude is mentioned. They can challenge it.
That is what that
was given to them before the Honorable Single Judge at least. So it is not the challenge that somebody else's go down was inspected and others images are being shown.
No, they say that these were not, copies were not given to them at the time of the inquiry. That is
the vacancy notice which my learned senior has submitted forms a law in itself.
And there is no scope of
does not require
prior hearing
to give them reasons for rejection and to supply them this inquiry report.
Even a hearing is not necessary. You can reject. Subsequently, since it has been challenged, the documents are produced.
That is why, my lord, everything is done in the.
Sorry. My lord, this is an electronic evidence. 65D, 65V says.
No, not even entitled to a hearing before rejection, Mr. Shorka. Since you have challenged, these have been produced. 65B, we won't go to that.
This forms part of the decision-making process. If I may submit, my lord, that the factual aspects.
You say that there is no, in a writ petition, it cannot be admitted in evidence. No marking of exhibits happens. But applying that principle, you did not oppose at the time of those documents being produced. Those copies were circulated to you, recorded by the learned signature. So admissibility point 65B is an admissibility.
Not at the time of hearing, but in court it was given.
Yes, but you did not take any objection. That is what you are saying. If we apply the principle of 65B, it's on admissibility, not evidence.
It was handed over. It was not by an affidavit. It was not on evidence. Consent, my lord, these documents were handed over. And the hearing commenced with consent.
It was not through any supplementary.
They had a right or
you handed over. You also handed over the control orders and everything.
The control order is a law, my lord. And this is not law. Anyway, man. Let him proceed.
There, yes.
My lord.
These were handed over at the time of hearing. They did not have any opportunity to.
The matter, my lord, was heard on one day only.
Said the first day.
At the very first day, it was decided because we said that we have all the documents available with us. It may be heard. And it was heard with consent. No way, my lord, was it recorded that we should disclose this document by way of an affidavit and they will deal with it. Not at least that recording was not. I was present at the time of hearing. My learned senior placed gave reply after receiving these documents. These are the documents which pertains to the inquiry report of the petitioner. Now, since the selection of private respondent has also been challenged, though
But you also, along with that, your the other argument is that since they have been shown to be ineligible, they don't have a right to look at
submission,
it.
since they are ineligible,
And therefore they cannot challenge even. I mean, after having participated, becoming unsuccessful, they cannot. The usual, the standard in
that is my first submission. Although since the Honorable Single Judge has gone into the merit of selection of the private respondent as well.
Yes.
So
let us see that.
I should place that as well. That is that starts at page number 41 of my opposition. Unlike petitioner, private respondents go down was inspected on 3rd of June. 31st, 1st, 2nd, 3rd. After 4 days, my lord.
Yes.
The petitioner made application prior to that of private respondent. His application was on 14th April. So we followed the sequences. My lord, kindly see clause number 52. Page 45, my lord.
Yes.
That is, my lord, the size of the go down of the private respondent. The minimum size was 300 and 100. Private respondent had 514 and 206. Then, my lord, kindly takes clause number 63. Character of land was recorded as Bash Bagan. However, my lord.
No, this is another sticking point. On the date of inspection, they had to comply. So if it was a Bash Bagan,
they have to comply provided they have not submitted their registered conveyance.
No, not about this submission of these documents, but your vacancy, that whatever.
Vacancy notification.
The vacancy there, yes. That also speaks about. We are not speaking about the document showing character of land as Dokan commercial vastu, but the other requirements, all the requirements at page 47, all those things. How could there be a floor, wall, roof, etc.?
The godown was constructed
on the Bash Bagan.
The character of land was only Bash Bagan.
In the records, it was shown as.
In the record, it was showing as Bash Bagan. There is a registered deed which was submitted by the private respondents. In that registered deed, it is mentioned that the land is now being used as VT land. VT, my lord, at your lordships, it's used as a residential purpose. And my lord, one of the condition is that of a condition mentioned in clause 10.7 of the vacancy notification. And another condition, another thing, my lord, is the form which was submitted by candidate. That's the statutory form which is part of the control order. My lord, that form says character of the land of the premises, Vastu, commercial, agricultural, etc. So there is a word etc. which gives some leeway. Now vacancy notice does not use the term etc. but the statutory form which they were, it was subsequently amended.
In 63, page 47, you state NB is there. If the land is of other character, the applicant needs to submit application for conversion on the date of application. Where do you get this? Page 47 of your opposition, sir. 63, against 63. Left hand column. That NB.
Within 3 months.
Yes.
Date of application.
Where do you get this? Is this provided anywhere? If the land is of other character, they have to submit an application for conversion.
I will, it is not there in the form.
But in any event, they had submitted application for conversion on that.
Application for conversion, my lord, it is written that they submitted it. না না, it was application টা তো পরে হয়েছিল। But this amendment was there, that at the time of application, my lord, the conversion application has to be submitted and the conversion certificate has to be obtained within 3 months from the date of offer of the FPS license. In this case, my lord, the conversion happened prior to the offer of the FPS license.
Where is the? Yes.
But application, my lord, was submitted. Conversion application, my lord, was submitted later, not on the date of the application.
So right hand side recording might have been wrong.
Might have been wrong. The record says so, my lord. It was submitted sometime in September.
But the vacancy that, what is the requirement? Where do you get it? This within bracket, this NB left hand column, this is provided in the control order.
My lord,
that it has to be submitted within conversion certificate within 3 months. We don't find it from the vacancy notice or anything of that. Where do you get it?
Form C,
Can we introduce something later on?
Well, statutory form C which we handed over. That is, it is wrongly quoted. আছে স্যার, ওটাও একটু দেখতে হবে, যেটা আপনারা দিলেন না কবেকার অ্যামেন্ডমেন্টটা কোনটা? 16?
Yes, it does.
The statutory form C which has been submitted,
yes, it does.
is of 16th September
This is short handed over,
2023.
yes, it is there.
But the vacancy is prior to that.
Oh,
1st
no.
September, so it might not be applicable, my lord.
This is 2013. The single page one was 2013.
Yeah, my lord.
Yes. Edaw.
So দিন না একটু আমাকে।
আমি দেব, উনি নেবেন।
Yeah.
2013 we had written because this was the only thing.
It's a 2013 control orders form, my lord.
Yes.
My lord,
The
book,
no.
the control order which is which forms the part of the book, my lord, it does not have that conditions mentioned. But my lord, on a date of inquiry, my lord, this condition was taken into consideration. The inspection, the date of vacancy is a
That
first.
form is here also, form C.
My lord, at that formula there will be a date of amendment of that particular clause.
Isn't there?
29/9/2023 সব কিছু হয়েছে, এটা তো দেখতে হবে।
September.
এটা ওয়ানটা কোথায় আছে? You know, this form C, which has been handed over to your lordship, is with effect from 29th of September 2023. Kindly see the first subscript.
Subsequent.
First, the vacancy notice was the 1st of September. Law as on the date of the vacancy, as has been held by the judgment of Tej Prakash Pathak, Constitutional Bench.
If that be so, then but you follow this. This is the form which contains that 3 months rider.
Before this form was
previous form is with you.
The application form, yes, that forms the part of the book. 75. একটু বইটা দিন না, clause 32. That has, candidates can have, that is the control order, 2013 control order. Kindly see clause 32. That is open. It has Bastu, commercial, agricultural, etc.
All right.
So that is why, my lord, I submitted that this gives some leeway
yes.
to the authorities as well as to the applicants. So, my lord, I have my I will object to that form, my lord, which is in effect from 29th of September 2023, because in my humble submission that form cannot be applied for a vacancy which was initiated prior to coming into effect of that form. Thereafter, I was at page number 47, my lord. kindly takes next clause, clause number 71 at page 48 of my opposition.
Yes.
Not 71C, 71A, whether the applicant is absolute owner, it says absolute owner. If yes, then what is the mode of his ownership? That is purchase. And then he has submitted the registered deed of conveyance. The registered deed, my lord, is of 2nd of May 2023. And which was registered on 18th of March 2024. Application, my lord, was made in April 2024. So the registered deed is prior to making of application.
Yes.
In the registered deed, my lord, the character of land is being shown as Bansbagan, but within bracket it says that within bracket it says that it is being used as VT. So the authority, after taking that registered deed into account, as per the vacancy notice, my lord, was not required to go in the second clause, clause B of subclause 10, subclause B of clause 10, my lord. Thereafter, the images of the private respondents go down is also there. It was complete with all plaster and electricity, everything was there. So, my lord, he was recommended as suitable candidate. That the recommendation is clause number 78. Your lordship,
if not blue-eyed boy, then suitable boy at least.
Suitable, my lord.
Yes.
That is the only thing which this inquiry officers can do. Inquiry officer has no power to declare their suitability. They can only record factual aspects. The suitability, my lord, is
not a subjective assessment. It was on the basis of
objective assessment, my lord.
Fair.
My lord, now this inquiry report was supposedly signed, the petitioner supposedly signed on blank paper. Inquiry happened in May 2024. He approached the writ court in October 2024 and obtained an order of consideration of his representation by the principal secretary. Principal secretary, my lord, after receiving the order of this court, held a preliminary inquiry, considered the submission of both parties. It was submitted that principal secretary directed re-inquiry, and his direction of re-inquiry effaced everything else which was done prior to that re-inquiry. In my humble submission, that thing is not born from the record of principal secretary's order. Principal secretary only directed another inquiry team, which is a separate inquiry team from the inquiry team which conducted previous inquiry, to relook into the matter. That relooking into the matter will not turn the clock back and give them another right of
validate their previous
inquiry. I mean, the second inquiry report is very interesting. It shows everything which has been recorded by the principal secretary's final order. That even the layout area, as which was present in during the first inquiry, has been changed. The construction has been made. The specification was placed by my learned senior. That specification appeared on the date of the second inquiry, which was in December 2024.
We also couldn't understand the meaning of the second inquiry, because obviously if a second inquiry is held, it's a post-dated inquiry.
But it is written there that everything is new construction.
And the scope of inquiry, as per the previous direction, was this whether regarding that blank paper signing and all those things. That was the scope of inquiry.
Since that was the allegation.
But probably all were clubbed together because there were two previous representations.
Principal secretary deemed it fit to construct
another inquiry today won't help to see the position which was
we
there.
Cannot see, we have GPS tagged images which cannot be relied upon.
And those copies of those were not given to them. Now, what is your answer to that? Because on there was another hearing pursuant to the direction of.
They were present before the principal secretary, before the re-inquiry was conducted and after the re-inquiry was conducted.
No, they were given a hearing before the second inquiry, at the time of second inquiry, but they were not given copies of these documents. That is what this.
These, after listening to their allegations, an inquiry was conducted by the team constituted by the principal secretary. That team gave their opinion to the principal secretary, and that opinion formed the basis of the order.
Did the previous or the first order grant any opportunity of hearing to them, that they were to be given hearing?
No, the first order did not. Second.
Inquiry.
70. During the first inquiry, their advocates were present.
Kindly see page 70.
Huh, sir.
Starts from page
No, the
70.
first order of Justice Samanto, the previous order.
First order
No,
is at
8
October 2024.
Where is that?
Page 68. After
Yes,
that inquiry was conducted in your lordship, kindly come to page 72, last paragraph. Learned advocate was
No,
represented.
directly
I will
to
place another.
consider the representation and pass it to
Kindly
the
take page number
order.
74.
After hearing the parties.
No, kindly take,
69.
kindly take 74. My lord, they were present. They made their submissions.
72. Bottom.
First time we were present. My lord, kindly see, apropos the first time presence, kindly see the order at page number 74.
Yes, yes.
Considering the above fact and circumstances, and after hearing the matter in compliance with the solemn order and judgment of Honorable High Court,
The appearance is recorded as Mr. Bhattacharya.
Page 72.
the undersigned is of the opinion that the team from head, I'm reading
But
page
then
number 74.
Mr. Sharkar takes a point that the hearing was vitiated because you did not give
My lord,
copies.
I will answer that only.
So we'll
Now,
continue
kindly
tomorrow.
take space number 74.
We'll continue tomorrow.
My lord, okay.
Heard in part for further hearing tomorrow.
My lord, tomorrow, my lord, if Mr. Bandyopadhyay commences his argument, my lord.
We'll hear you. Yes, tell him. Because as reasons say that the continuity will be lost. The quotas, we have said that.
As well.
Take a look to the